and again and again. As the January 6th committee was still staffing up, we held our initial hearing. Our witnesses were 4 members of the Capitol and Metropolitan Police Departments. Nearly 7 months had passed since January 6th, and Chairman Thompson wanted to begin our investigation by reminding everyone of that day's intense and inexcusable violence. I regarded this initial hearing as an opportunity to frame exactly what we were about to spend the next 18 months doing, and to give people a sense of why it mattered. Here's what I said in my opening remarks.
We must know what happened here at the Capitol. We must also know what happened every minute of that day in the White House, every phone call, every conversation, every meeting leading up to, during, and after the attack. Honorable men and women have an obligation to step forward. If those responsible are not held accountable, and if Congress does not act responsibly, this will remain a cancer on our constitutional republic, undermining the peaceful transfer of power at the heart of our democratic system. We will face the threat of more violence in the months to come and another January 6th every 4 years.
I wanted to describe exactly why I had joined the January 6th committee, despite the certainty of dramatically negative political consequences for me.
The question for every one of us who serves in Congress, for every elected official across this great nation, indeed for every American, is this: will we adhere to the rule of law? Will we respect the rulings of our courts? Will we preserve the peaceful transition of power? Or will we be so blinded by partisanship that we throw away the miracle of America? Do we hate our political adversaries more than we love our country and revere our Constitution? I pray that that is not the case. I pray that we all remember our children are watching as we carry out this solemn and sacred duty entrusted to us. Our children will know who stood for truth, and they will inherit the nation we hand to them, a republic if we can keep it.
As our inaugural hearing moved to the witnesses and the evidence, we played a collection of verbatim audio and video clips from several of the violent rioters.
Okay, guys, apparently this tip of the spear has entered the Capitol building.
Can I speak to Pelosi? Yeah, we're coming, bitch! Oh, my bitch, we're coming for you too, fucking traitor!
They've got the gallows set outside this Capitol building. It's time to start fucking using them.
Start making a list, put all those names down, and we start hunting them down one by one!
Then Sergeant Aquilino Ganell and officers Michael Fanone, Daniel Hodges, and Harry Dunn, wearing their dress uniforms, shared compelling accounts of how they had been accosted, attacked, and injured. It is well worth remembering what each of these men told us. Dragged from the police line in the Capitol's west entrance and savagely beaten by Trump supporters, Officer Fanone sustained multiple very serious injuries. Here's how he recounted that traumatic experience.
I can remember looking around and being shocked by the sheer number of people fighting us. As my police body-worn camera shows, thousands upon thousands of people seemingly determined to get past us by any means necessary. At some point during the fighting, I was dragged from the line of officers and into the crowd. I heard someone scream, "I got one!" As I was swarmed by a violent mob, they ripped off my badge. They grabbed and stripped me of my radio. They seized ammunition that was secured to my body. They began to beat me with their fists and with what felt like hard metal objects. At one point, I came face to face with an attacker who repeatedly lunged for me and attempted to remove my firearm. I heard chanting from some in the crowd, "Get his gun," and kill him with his own gun. I was electrocuted again and again and again with a taser. At the hospital, doctors told me that I had suffered a heart attack, and I was later diagnosed with a concussion, a traumatic brain injury, and post-traumatic stress disorder.
Officer Hodges had been defending one of the doorways on the West Front as the mob surged forward. Here is some of what he told us.
The acrid sting of CS gas or tear gas and OC spray, which is mace, hung in the air as the terrorists threw our own CS gas canisters back at us and sprayed us with their own OC. Either they bought themselves or stole from us. Later, I learned at least one of them was spraying us in the face with wasp spray. Eventually, there was a surge in the crowd. The fence buckled and broke apart, and we were unable to hold the line. A chaotic melee ensued. Terrorists pushed through the line and engaged us in hand-to-hand combat. Several attempted to knock me over and steal my baton. One latched onto my face and got his thumb in my right eye, attempting to gouge it out. I cried out in pain and managed to shake him off. Before any permanent damage was done. The mob of terrorists were coordinating their efforts now, shouting, "Heave! Ho!" as they synchronized, pushing their weight forward, crushing me further against the metal door frame. The man in front of me grabbed my baton that I still held in my hands, and in my current state, I was unable to retain my weapon. He bashed me in the head and face with it, rupturing my lip and adding additional injury to my skull.
Sergeant Aquilino Ganell gave similarly harrowing testimony.
The rioters called me traitor, a disgrace, and shouted that I, an Army veteran and a police officer, should be executed. "We'll get our guns. We'll outnumber you," they said. But the physical violence we experienced was horrific and devastating. My fellow officers and I were punched, kicked, shoved, sprayed with chemical irritants, and even blinded with eye-damaging lasers by a violent mob, who apparently saw us, law enforcement officers, dedicated to ironically protecting them as U.S. citizens, as an impediment to their attempted insurrection. The mob brought weapons to try to accomplish their insurrectionist objectives and use them against us. These weapons included hammers, rebars, knives, baton, and police shields taken by force, as well as bear spray and pepper spray. I could feel myself losing oxygen and recall thinking to myself, this is how I'm going to die, defending this entrance.
The testimony of these men reminded us that only a percentage of the crowd outside the Capitol had managed to gain entry to the building. Thousands of angry and armed rioters on the West Terrace had tried to break through, fighting with officers who successfully but at a high cost, held their ground, and defended the entrances. Had the officers not held the line, many thousands more rioters would have entered the Capitol, bearing the weapons many carried. The situation could have been far worse. Officer Dunn recalled struggling to process what he was seeing.
I was stunned by what I saw. In what seemed like a sea of people, Capitol police officers and Metropolitan police officers, MPD, were engaged in desperate hand-to-hand fighting with rioters across the West Lawn. Until then, I had never seen anyone physically assault Capitol Police or MPD, let alone witness mass assaults being perpetrated on law enforcement officers. I witnessed the rioters using all kinds of weapons against officers, including flagpoles, metal bike racks that they had torn apart, and various kinds of projectiles. Officers were being bloodied in the fighting. Many were screaming, and many were blinded and coughing from chemical irritants being sprayed in their faces.
Officer Dunn recounted racial slurs being hurled at him by the rioters as he fought to defend the United States Capitol building. Images from that day had shown members of the mob that invaded the Capitol wearing anti-Semitic and neo-Nazi insignia. Another chilling part of Officer Dunn's testimony drove home the sheer enormity of our task. As the riot began, he had received a social media post forwarded by text suggesting that Trump supporters had an organized plan to surround and invade the Capitol by day, and then return later with firearms.
It said, amongst other things, that Trump has given us marching orders and to keep your guns hidden. It urged people to bring your trauma kits and gas masks, to link up early in the day in 6 to 12-man teams. It indicated there would be time to arm up.
We ultimately learned that members of the Oath Keepers, who have since been convicted of seditious conspiracy, did indeed have a plan to arm up that evening. But at the time of our initial July 2021 hearing, our information about the pre-planning by the many militia groups present and the links among those groups was largely skeletal. We had a very long way to go and a short time to get there. The next day, I ran into a group of students from Miami University of Ohio outside the Capitol building, talking with Jamie Raskin. It was a typical Washington summer evening, hot and humid, with the sky a hazy pink as the sun began to set. Jamie told the students it was my birthday, and they responded with a memorable rendition of Happy Birthday. They also had insightful and informed questions about January 6th and the work of the committee. As the conversation wound down and the group started to leave, one of the students, a young woman, came over to talk to me. I remember what she said as we stood together on the steps of the Capitol. "I don't know if I agree with you on any policy issues," she told me, "but I want to be part of fighting for our Constitution with you." It was a sentiment I would hear over and over in the coming months, especially from young women. I was moved to tears more than once by these young Americans who seemed to understand, often better than people many years older, what was at stake and what it will take to save our republic. 33. Hideaway. Former Senator Mike Enzi of Wyoming had retired from office at the end of 2020. Mike was an honorable and good man, an outstanding senator, and a dear friend. Wyoming's congressional delegation is small, so Senators Enzi, Barrasso, and I worked together often. We usually appeared at the same events across our state. I especially loved seeing Mike and his wife Diana surrounded by their grandkids as we rode in county fair parades every summer. Mike was the only CPA in the Senate, and I valued his wisdom, experience, and guidance, particularly as we dealt with budget issues every year. He had a dry sense of humor, and he loved to fish, like my dad. After Mike retired, he still followed what was happening in Congress, and he knew the backlash I was facing in Wyoming. Occasionally, he would send me texts, urging me to be courageous. He was a man of deep faith, and I especially treasured the prayers and scripture he sent me during this time. One morning, his message to me was from Psalm 7, 6 through 11. My shield is God Most High, who saves the upright in heart. Mike passed away after a cycling accident at the end of July 2021. His memorial service was held in the event center in the Enzies' hometown of Gillette, Wyoming. It was a moving ceremony celebrating Mike's love of family, of Wyoming, and of America. A military flight had been arranged to bring many members of the United States Senate to Wyoming for the service. I was seated in the front row when the senators filed into the auditorium to take their seats. As they walked past and we greeted each other, more than a few of the Republicans leaned over and quietly said some version of, "You're doing great. Thanks for standing up and doing what's right." I appreciated the support, but I couldn't help thinking that each of them could be speaking out as well. Over the course of the summer, a few key former staffers from the Trump White House had begun quietly reaching out to Adam Kinzinger and to me. One of these was Alyssa Farah Griffin, who had been press secretary to Vice President Pence, as well as director of the White House Office of Strategic Communications, before she resigned from the administration in early December of 2020. She had been direct and public in her condemnation of the events leading up to and during January 6th. Alyssa informed us that Sarah Matthews would be willing to come in to speak with me off the record. Matthews had been the deputy White House press secretary. She resigned on the evening of January 6th. We knew that she likely had first-hand information about the events inside the West Wing that day, including while the attack was underway. A few weeks earlier, Jamie Fleet, the House Administration Committee staff director, had handed me the keys to a small, windowless office tucked into the basement of the Capitol building. To reach it, you descended a short flight of steps to an unmarked door next to a large set of pipes running the length of the hallway. It was a convenient place to work and to hold meetings, especially with individuals whom the press would no doubt recognize had they come to meet with me in my main office in the Cannon House office building. This hideaway is where Alyssa Griffin, Sarah Matthews, and I met one day in early October of 2021. The world would hear Sarah's testimony a few months later when she appeared in a public hearing of the January 6th committee. As I listened to her tell her story in the Capitol basement office that fall day, I was impressed by her strength, composure, and courage. Later that month, I set up another private meeting, this time with former Deputy National Security Advisor Matt Pottinger. I called Matt and asked if he would be willing to speak informally with committee lawyers John Wood, Tim Heaphy, and me. When Pottinger agreed, I arranged for the four of us to meet in a room at the Army-Navy Club in Northwest Washington. As the sun went down outside the windows of the club, Matt walked us through the awful hours of January 6th inside the West Wing. The memories were painful ones. Matt, a Marine, understood the magnitude of Donald Trump's dereliction of duty. He took no pleasure in recounting what had happened. By the fall of 2021, we had further refined our investigative plan. We had comprehensive lists of White House and Trump administration personnel and a roadmap as to who might be willing to cooperate and provide information. We had begun issuing subpoenas and pursuing witness testimony. It was increasingly clear that the sheer volume of information, the number of witnesses involved, and the time constraints under which we were working meant that we needed to accelerate our investigative efforts and materially enlarge our staff. This was one of many times that I turned to Jamie Fleet and Terry McCullough. With the support of Chairman Thompson and Speaker Pelosi, they were able to jumpstart the effort to hire more attorneys and secure all the resources we needed. Jamie and Terry were integral to many important elements of the committee's work, including keeping everyone on the same page and keeping our staff and members focused on our task. Late in September of 2021, veteran journalist Leslie Stahl interviewed me on 60 Minutes. The bulk of the interview covered the January 6th committee's investigation. I wanted to reinforce the fact that we were conducting a bipartisan and professional process. But she also asked a political question: whether my decision to oppose Trump on and after January 6th had been a calculated political move. There wasn't a yellow pad with the pros and cons, she asked. The answer was easy. My decision had not been driven in any way by politics, and I told her so. No, I watched while the attack was underway, understood very clearly what he did on January 6th, what he failed to do on January 6th. Instead of stopping the attack while it was underway, he was busy calling up senators, trying to get them to delay the electoral count. So there was no calculation. I think he's very dangerous. I had made the decision in the midst of the January 6th attack to vote to impeach Donald Trump. It was the right decision when I made it, and I was still doing what I knew was right, regardless of the impact it might have on my political prospects. Of course, I knew that my decision to join the Select Committee was directly contrary to the advice any campaign consultant, or even the most casual observer of politics, would have given me. Nobody who knew anything about Wyoming or Republican politics would genuinely believe that voting to impeach Donald Trump or agreeing to serve on the January 6th committee was helping me politically. Around this time, campaign consultants who worked for me began to receive threats, including from Kevin McCarthy's political operation, that they would be blackballed by all other Republican campaign entities if they continued to work for me. I was proud of and grateful for the handful who stayed with me, regardless of the McCarthy threat. One consultant told me he had lost business and friends, but at least he could sleep at night. 34. Winning in court. By October of 2021, what Phil and I had anticipated in the early phase of the investigation played out. A number of our initial subpoenas met significant resistance. We were aware of the House counsel's view at that time that efforts at civil enforcement of a subpoena could fail due to an unfavorable D.C. Circuit Court decision in an unrelated case. Whereas the Senate has clear statutory authority to enforce their subpoenas, the House counsel cautioned us that the House of Representatives lacked such clear authority. In addition, he warned that pursuing civil enforcement of our subpoenas, even if ultimately successful, could take years. These were make or break moments in our investigation. If we didn't move aggressively, witnesses would conclude that they could defy our requests for interviews and documents. We would not be able to secure the evidence our investigation required. When Donald Trump's former chief strategist, Steve Bannon, defied our subpoena, we did not hesitate to act. The committee immediately took steps to seek a criminal contempt citation against Bannon, who had refused to appear for testimony or turn over any documents to the committee. Bannon had left his job as a White House advisor back in 2017, but nevertheless, he was trying to assert some form of executive privilege or absolute immunity for his interactions with Trump. We already understood that Bannon would be a key witness, not least because of what he had said on January 5th. All hell is going to break loose tomorrow. It's going to be quite extraordinarily different. All I can say is strap in. Tomorrow, he said, is game day. So many people said, man, if I was in the revolution, I would be in Washington. Well, this is your time in history. This is what I explained on the House floor during the debate on whether Bannon should be held in contempt.
I urge all Americans to watch what Mr. Bannon said on his podcast on January 5th and 6th. He said, quote, "We are coming in right over the target. This is the point of attack we have always wanted." Mr. Bannon's own public statements make clear he knew what was going to happen before it did, and thus he must have been aware of and may well have been involved in the planning of everything that played out on that day. The American people deserve to know what he knew and what he did.
We later learned that Bannon also had information about Trump's plans even before the 2020 election, and that Trump had planned in advance, before a single vote was counted, to lie about the election being stolen. In other words, Trump's plan was premeditated. Here is Bannon speaking to a group from China.
And what Trump's going to do is just declare victory, right? He's going to declare victory. But that doesn't mean he's the winner. He's just going to say he's the winner. That's our strategy. He's just going to declare himself a winner. So when you wake up Wednesday morning, it's going to be a firestorm. Also, if Trump is losing by 10 or 11 o'clock at night, it's going to be even crazier. No, because he's going to sit right there and say they stole it.
That is exactly what Donald Trump did. After the Select Committee met on October 19, 2021, and approved the contempt report on Steve Bannon, Chairman Thompson and I testified the next day before the House Rules Committee as part of the formal process for moving a contempt resolution to the full House. The Rules Committee is one of the oldest committees in the House. The Speaker uses this committee to control what legislation reaches the floor of the House, including which amendments will be allowed and how much time there will be for debate. A total of 13 members of Congress sit on the Rules Committee, 9 from the majority and 4 from the minority. This larger than 2-to-1 ratio is meant to ensure that the majority and the Speaker can always maintain control. The committee meets in a small, ornate hearing room on the top floor of the Capitol building. It often meets late into the night. Unlike in other committees, there is no time limit for debate in rules. Each committee member may take however long they wish to ask as many questions as they choose. Paul Ryan appointed me to the Rules Committee during my first year in Congress. I had initially been reluctant to join because I knew it would be a huge commitment of time, and frankly, because I didn't fully understand how important the committee is. But Ryan was persuasive, and my time on the committee turned out to be invaluable. There's no better place to learn how the House of Representatives works, to be able to speak on and influence every major piece of legislation, and to gain insights into the personalities, politics, and procedures that characterize the House itself. I left the Rules Committee in 2018 when I was elected chair of the House Republican Conference. When I walked into the committee's top floor hearing room with Chairman Thompson on October 20th, 2021, to testify about the Bannon contempt resolution, it was my first time back in 3 years. We took our seats at the witness table, just a few feet from the members of Congress sitting on the committee dais. When it was my turn to speak, I directed my remarks to my Republican colleagues. I thanked the Republican ranking member Tom Cole and said, "We've been through a lot together. We're not just colleagues, we're friends. And I served with a number of you on this committee for 2 years when we were in the majority. I could not have imagined then that we would meet again like this." As I continued, I described very frankly what other Republicans were telling me about how they would vote on the Bannon contempt resolution. They say they just don't want this target on their back. They're just trying to keep their heads down. They don't want to anger Kevin McCarthy, the minority leader, who's been especially active in attempting to block the investigation of the events of January 6th, despite the fact that he clearly called for such a commission the week after the attack. I ask each one of you to step back from the brink. I urge you to do what you know is right. I wasn't expecting to sway any of the 4 Republican votes in the Rules Committee, but I knew what Tom Cole had said a couple of days after January 6th, that there were real grounds for impeaching Donald Trump, and I wanted to remind them that history was watching. As you cast your votes, think about how you will answer when history asks, "What did you do when Congress was attacked?" When a mob, provoked by a president, tried to use violence to stop us from carrying out our constitutional duty to count electoral votes. When a mob, provoked by a president, tried to overturn the results of an election. Will you be able to say you did everything possible to ensure Americans got the truth about those events? Or did you look away? Did you make partisan excuses and accept the unacceptable? When the chairman and I finished our testimony, Jim Jordan and Florida's Matt Gaetz testified in opposition to the contempt resolution. Jordan said repeatedly that the Select Committee should not be investigating the January 6th attack because the Department of Justice and the FBI already had a criminal investigation underway. Jordan even praised the job that the DOJ and the FBI were doing in that investigation. It bears repeating. At this point in the fall of 2021, Jim Jordan was saying that investigating January 6th, including what Donald Trump did on that date, was the job of the Department of Justice. Today, Jordan calls that same investigation the weaponization of the Justice Department. During Jordan's testimony, Rules Committee Chairman Jim McGovern questioned him about his telephone calls with Donald Trump on January 6th. Jordan struggled to furnish a consistent answer. Initially, he simply avoided answering. Then Jordan confirmed that he had talked to Trump on January 6th. He said he couldn't remember how many times, but he was sure it was only after the attack. Next, McGovern read him a news story that quoted Jordan saying he was sure one of the calls took place while he was in the Ways and Means Committee room, the room in which members sheltered during the attack. Jordan deflected, but a few moments later seemed to confirm the story was accurate. McGovern asked Jordan about notes taken by Acting Deputy Attorney General Richard Donahue during a December 2020 phone call, during which President Trump had instructed Donahue to, quote, just say the election was corrupt and leave the rest to me and the Republican congressman. Elsewhere in the call, the president specifically mentioned Jim Jordan and Pennsylvania Republican Representative Scott Perry. So McGovern naturally asked, did you discuss with President Trump a coordinated effort to overturn the results of the election? Jordan laughed nervously and said he had no idea what McGovern was talking about. Perhaps Jordan could have benefited from the advice of a good criminal lawyer before giving this testimony. Tom Cole seemed to recognize the hole that Jordan was digging, so he said to Jordan,
you should not be on trial here for, if somebody wants to talk to you, they can, charge you with something. I guess they could do that. Or if the select committee wants to call you, I guess they could do that. But I think you're here to talk about the testimony and, your view of the subpoena.
Cole said he wanted to offer Jordan the opportunity to add anything to his comments. Jordan responded in part by admitting that he had talked to Trump on January 6th after members had been evacuated from the chamber, and said, I may have talked to him before, I don't know. On October 21st, 2021, the House of Representatives voted to hold Steve Bannon in contempt of Congress. 9 Republicans supported the resolution. Scarcely 3 weeks later, the Department of Justice indicted Bannon. He was tried during the summer of 2022, convicted, and sentenced to 4 months in federal prison. As of the fall of 2023, his case was still on appeal. As our work on the January 6th committee progressed, I began to receive more and more threats, and security again became an issue. Speaker Pelosi assigned a Capitol Police detail that was with me until our investigation concluded at the end of 2022. These brave men and women demonstrated true professionalism, skill, flexibility, and dedication to duty. There were moments when, especially in Wyoming, a misinformed individual would assert some unfounded claim, such as January 6th was not really all that violent. As these law enforcement officers, some of whom had valiantly fought off assailants that day, stood just a few feet away. They never reacted or showed a trace of anger. Near the end of my time in Congress, a Capitol Police officer on my detail told me he could be seen in one of the videos we had shown in a Select Committee hearing. In that footage, he is donning tactical gear as Proud Boys advance on the Capitol. 35. The Meadows text messages. By the fall of 2021, it was becoming clear that Mark Meadows would likely also refuse to testify. We might need to pursue contempt for him as well. I knew Mark and had worked with him during his time representing North Carolina in Congress, and occasionally after he'd gone to work in the White House. I never believed that Mark was suited to the role of White House Chief of Staff. I thought he was in over his head, that he lacked the gravitas and judgment required to do the job well. I doubted that Meadows would ever say no to Donald Trump. My experience with Mark further led me to believe that he would say whatever Trump told him to say about January 6th. The January 6th committee subpoenaed Meadows, seeking a host of his communications, including text messages and emails, related to Trump's efforts to overturn the 2020 election. Mark was represented by George Terwilliger, whom I knew from my early days as a practicing lawyer. George was a senior partner in the law firm that I had joined just out of law school. I was surprised by George's initial letters to the committee on Mark's behalf. Among other things, they said, quote, "We believe that any documents responsive to that subpoena would not be in Mr. Meadows' personal care, custody, or control, but rather would be in the possession of the Archivist of the United States." This suggested that Meadows had no relevant material on his personal cell phone, a notion that was highly suspect. I knew Meadows used his personal cell to communicate with members of Congress, for example. He had texted and called me from his private cell repeatedly over the years, including when he was White House Chief of Staff. Knowing George Terwilliger, I was reluctant to believe that he would intentionally try to deceive us. It was much more likely that Meadows was lying to Terwilliger about the communications on his private cell. Was Mark Meadows really so afraid of Donald Trump that he would lie to his own lawyer? And if so, what exactly was he trying to hide? We were negotiating with Meadows' counsel about exactly what information Meadows would be willing to address in a select committee interview. We also continued to request information contained in his private email accounts and cell phone texts. We were increasingly specific about the contents of his private cell phone, even identifying the personal number I knew Meadows had used. Perhaps unaware that Meadows might be lying, and in fact had relevant texts on his cell, Terwilliger committed to us that he would provide any contents of Meadows' private phone and email, subject, of course, to privilege claims. By early December, the committee began to receive Mark Meadows' private cell phone text messages and emails. Terwilliger claimed privileges to many of these messages, asserting that they were covered by executive privilege, attorney-client privilege, and what Terwilliger called marital privilege. Some of those privilege claims seemed overbroad and unjustified, but having committed to provide the committee with non-privileged material, Terwilliger had little choice but to supply us with thousands of messages that Meadows had exchanged with people outside the Trump administration. These messages went to and from Fox News hosts, members of Congress, members of President Trump's family, and many others. We weren't seeing everything, but we were seeing a great deal. When I saw the text messages, I knew what would happen. Terwilliger was not going to let Meadows appear for any committee interview, under any circumstances. No privilege could prevent Meadows from testifying about the text messages he had provided to the committee, and his testimony would likely be very damaging, both to himself and to Donald Trump. The texts would also make it very difficult for Meadows to lie to us. We predicted that Terwilliger would pull the plug on our negotiations and invent a pretext for Meadows not to testify. This is exactly what Terwilliger did, just one day before our scheduled interview. He argued that he was canceling Meadows' appearance because the January 6th committee had, quote, issued wide-ranging subpoenas for Meadows' communications. Terwilliger simultaneously filed a lengthy complaint in a civil suit against the committee, asking a court to excuse Meadows' failure to comply with our subpoena. Meadows' refusal to appear and testify about text messages and emails that were not covered by any potential privilege put him clearly in contempt of Congress. We knew that Mark Meadows had pivotal information on Donald Trump's efforts to overturn the election, and the committee needed his testimony. We also knew that other witnesses would be watching to see if Meadows was able to defy our subpoena. We moved quickly once again to bring a contempt resolution to the House floor. In early December, Mark Meadows had appeared on Sean Hannity's Fox News show to complain that the committee was pressuring him to testify. Hannity remarked, "Liz Cheney's mission is to align with people who called her father a murderer, war criminal, and crook." Meadows suggested that he was trying to cooperate, but it was already clear that he did not intend to do so. We needed to show that we meant business, and that we would not be cowed or pressured by Sean Hannity, Mark Meadows, or anyone else. The committee's public presentations regarding Meadows' contempt needed to be careful and scrupulously factual, with no politics or spin. They needed to plainly lay out the evidence we had to justify our conclusion that Meadows was obligated to testify. We also needed to explain to the American people exactly why the information was relevant legally and why we were taking the dramatic step of pursuing testimony from Donald Trump's White House Chief of Staff. It was important to be clear that the committee understood the gravity of moving to hold a former White House Chief of Staff in contempt of Congress. When the committee convened on December 13th to consider the resolution holding Meadows in contempt, I explained in my opening remarks, we do not do this lightly, and indeed we had hoped not to take this step at all. However, Mark Meadows had important information, including about a crucial area of our investigation: what exactly Donald Trump had been doing for 187 minutes while the Capitol was besieged by rioters on January 6th. Mark Meadows had sent and received a long series of text messages directly relevant to that topic. The texts left no doubt that those in the White House knew exactly what was happening at the Capitol. I began to read the messages from the dais.
One text Mr. Meadows received said, quote, "We are under siege here at the Capitol." Another, quote, "They have breached the Capitol." In a third, "Mark, protesters are literally storming the Capitol, breaking windows on doors, rushing in. Is Trump going to say something?" A fourth, "There's an armed standoff at the House chamber door." And another from someone inside the Capitol, "We are all helpless." Dozens of texts, including from Trump administration officials, urged immediate action by the president. Quote, "POTUS has to come out firmly and tell the protesters to dissipate. Someone is going to get killed." In another, "Mark, he needs to stop this now." A third, in all caps, "Tell them to go home." A fourth, and I quote, "POTUS needs to calm this shit down." Indeed, according to the records, multiple Fox News hosts knew the president needed to act immediately. They texted Mr. Meadows, and he has turned over those texts. Quote, "Mark, the president needs to tell people in the Capitol to go home. This is hurting all of us. He is destroying his legacy," Laura Ingraham wrote. "Please get him on TV. Destroying everything you have accomplished," Brian Kilmeade texted. Quote, "Can he make a statement? Ask people to leave the Capitol," Sean Hannity urged. As the violence continued, one of the president's sons texted Mr. Meadows, quote, "He's got to condemn this shit ASAP. The Capitol Police tweet is not enough," Donald Trump Jr. texted. Meadows responded, quote, "I'm pushing it hard. I agree." Still, President Trump did not immediately act. Donald Trump Jr. texted again and again, urging action by the president. Quote, "We need an Oval Office address. He has to lead now. It has gone too far and gotten out of hand," end quote. But hours passed without necessary action by the president.
And I explained exactly why all of this was relevant to our investigation.
These non-privileged texts are further evidence of President Trump's supreme dereliction of duty during those 187 minutes. And Mr. Meadows' testimony will bear on another key question before this committee. Did Donald Trump, through action or inaction, corruptly seek to obstruct or impede Congress's official proceedings to count electoral votes? Mark Meadows' testimony is necessary to inform our legislative judgments.
Those texts were not the only reason we were seeking Mark Meadows' testimony. We knew he had firsthand knowledge about matters at the heart of our investigation. matters about which there was no possible executive privilege claim. For example, Meadows had participated in Donald Trump's call with Georgia Secretary of State Brad Raffensperger on January 2nd, when Trump had pressured Raffensperger to find 11,780 votes. Meadows had texted with others on the call while it was underway. We also knew from the texts that Meadows, in the days before January 6th, had been working with Congressman Scott Perry to try to replace the leadership of the Department of Justice. No claim of executive privilege could cover that testimony either. I ended my remarks in the committee meeting this way.
January 6th was without precedent. There has been no stronger case in our nation's history for a congressional investigation into the actions of a former president. This investigation is not like other congressional inquiries. Our Constitution, the structure of our institutions, and the rule of law, which are at the heart of what makes America great, are at stake. We cannot be satisfied with incomplete answers or half-truths, and we cannot surrender to President Trump's efforts to hide what happened. We will be persistent, professional, and nonpartisan, and we will get to the objective truth to ensure that January 6th never happens again.
Meadows' texts to and from Fox News hosts brought more scrutiny to what Fox had been broadcasting in the weeks leading up to January 6th. Fox News had been particularly active in spreading Donald Trump's intentionally false election fraud claims. It was important for the public to realize that Fox personalities were simply not leveling with the network's viewers. Sean Hannity, for example, had privately expressed concerns in advance of January 6th. He texted Meadows on January 5th, "I'm very worried about the next 48 hours." Hannity also knew about the plan to pressure Pence to refuse to count electoral votes. He sent Meadows this text on January 5th, "Pence pressure, White House counsel will leave." In the days just after January 6th, Hannity regarded Donald Trump as someone who needed to be watched and managed very closely. That much was evident from his texts on January 7th to Kayleigh McEnany and his texts on January 10th with Mark Meadows. Of course, Hannity didn't say any of that on the air. Fox News had changed considerably since the days when I worked there over a decade ago. Back then, Charles Krauthammer was a regular panelist, providing brilliant, insightful, and responsible analysis. Charles had been the conscience of Fox News. The network had never been the same since his passing in 2018. In 2023, discovery materials from Dominion Voting Systems' defamation suit against Fox appeared to reinforce this point. Court documents, including deposition testimony, as well as email and text exchanges, appear to indicate that Fox News hosts and executives knew the election fraud claims were false, despite what Fox News was broadcasting to its viewers. Sean Hannity, for example, had reportedly testified that he never believed Trump's claims that Dominion machines had stolen the election from Trump. "I didn't believe it for 1 second," he said. In a text exchange with Tucker Carlson about Sidney Powell and Rudy Giuliani, Laura Ingraham allegedly said, "Sidney is a complete nut. No one will work with her." Ditto with Rudy. Dana Perino reportedly referred to the election fraud claims as total BS, insane, and nonsense. And Fox Corporation CEO Rupert Murdoch reportedly said in an email about January 6th, "Wake-up call for Hannity, who has been privately disgusted by Trump for weeks, but was scared to lose viewers." Fox settled the Dominion litigation for $787 million. The Meadows texts would help illuminate another key question for the committee, which I asked this way near the end of my remarks. Did Donald Trump, through action or inaction, corruptly seek to obstruct or impede Congress's official proceeding to count electoral votes? This was a reference to a specific federal criminal statute, 18 U.S.C. Section 1512c2, which makes it a crime to corruptly obstruct Congress's official proceeding to count electoral votes. Phil, along with our daughter Elizabeth, had been following the Justice Department prosecutions of individuals involved in attacking the Capitol. These cases were being heard in the federal courthouse in the District of Columbia. Phil had spent decades litigating cases there and correctly predicted most of the judge's rulings on these charges. His instinct was that Section 1512C2, along with certain other criminal statutes, might be applied to Trump and others involved in his attempt to overturn the election. We recognized, for example, that Donald Trump and his team had coordinated an effort to create fraudulent electoral vote certifications in states that Joe Biden had won, to send these false slates to Congress for January 6th, and to pressure Vice President Pence to disregard the genuine certifications from those states. We were in the process of evaluating whether Section 1512C2 could apply to that conduct. After my remarks, a much more public discussion began about the criminal charges the Department of Justice might consider against Donald Trump and other individuals who had attempted to overturn the election. And in the months that followed, a federal judge concluded that Donald Trump and his advisor John Eastman had likely violated Section 1512C2 and at least one other criminal statute in their many efforts to overturn the election. 36. Presidents are not kings. While the Bannon and Meadows contempt processes were underway, we were simultaneously litigating the case brought by Donald Trump to challenge the January 6th committee's subpoena to the National Archives. Trump had asked for an injunction, halting the archives from supplying us with the White House documents our investigation needed. This was an all-hands-on-deck effort for the committee, and many are owed thanks, including the Office of the Counsel for the House of Representatives. We worked together to move the initial stages of this litigation quickly and aggressively. We won in federal district court on November 9th, 2021, in a highly expedited process. Judge Tanya Chutkin ruled that former President Trump could not prevent the committee from accessing the relevant documents. The court's well-written opinion was memorable and widely quoted for this point: presidents are not kings, and plaintiff is not president. Trump appealed the ruling. The appeals process was similarly highly expedited. Oral arguments were held on November 30th, 2021, and an exceptionally well-reasoned 68-page decision was issued just 10 days later. The court concluded that the January 6th committee has demonstrated a sound, factual predicate for requesting these presidential documents specifically. There is a direct linkage between the former president and the events of January 6th. The court also concluded that our committee would have been entitled to the presidential documents even if Donald Trump were the sitting president. This last point was critical. Despite the fact that President Biden had waived executive privilege with respect to the documents the committee sought, we suspected that some Supreme Court justices might believe a former president could still assert an executive privilege claim. But after weighing all the relevant interests, the appellate court had concluded that Donald Trump could not have blocked the committee's access to these documents even if he were still president. Phil and I believed the committee had an excellent chance of success in the Supreme Court, that we might get anywhere from 5 to 8 votes, possibly all but that of Justice Clarence Thomas. The House Counsel's office was not as optimistic, suggesting we might not get even 4 justices. They warned that the Supreme Court might not take any action until June 2022, which would have been a disaster for us, given the committee's need to obtain the documents, question the witnesses, and begin the hearings by that time. I witnessed this sort of disconnect with the House Counsel's office a few times during the investigation. We tended to view most judges appointed by Republican presidents, including those nominated by President Trump himself, as fair-minded and principled. We believed they were likely to recognize the importance of the information the committee needed. The House Counsel's office, by contrast, was far more negative in assessing our chances before judges or justices appointed by a Republican president. Sometimes that office wanted to avoid litigation altogether. At one point, they suggested that we should let the Justice Department litigate against Trump alone, without our participation in the briefing at all. That seemed counterproductive. We needed to stand and fight. I knew we would not encourage witnesses to cooperate with our investigation by retreating in the face of our first major challenge. Throughout all these discussions, Speaker Pelosi supported my position. We did not back down. Ultimately, the Supreme Court issued its 8-1 ruling in our favor on January 19, 2022. As we had foreseen, only Justice Thomas dissented. The court explained, because the Court of Appeals concluded that President Trump's claims would have failed even if he were the incumbent, his status as former president necessarily made no difference to the court's decision. From start to finish, this litigation was astonishingly fast, and this success materially strengthened the committee's hand. 37. Legitimate political discourse. Although most members of the January 6th committee had personally witnessed elements of the attack, we still needed a much more granular understanding of what transpired at the Capitol that day. We needed to see where the breaches had occurred, where police officers had been attacked, where each element of the battle had been fought. And we needed to walk the route the mob had taken through the Capitol hallways. We knew if we did this during the day, it would become a press event. We therefore made plans to spend several hours, late one night at the end of 2021, getting a walkthrough and a briefing on precisely what had happened in the Capitol, including from officers who fought that day. On the plaza on the west front of the Capitol, officers showed us where reinforcements from the Metropolitan Police Department of the District of Columbia had arrived at a crucial moment in the battle. We walked up the steps inside the Capitol, where the mob had threatened Officer Eugene Goodman, who courageously lured them away from the Senate chamber. We stood in the gallery of the United States Senate, where members of the mob, carrying zip ties and wearing tactical gear, had been photographed climbing over the seats and jumping down onto the Senate floor. We saw the stairway down which Vice President Pence and his family had been evacuated. We walked through the hallways and conference rooms in the office suite of the Speaker of the House, where staff members had barricaded themselves for hours as the mob rampaged just outside, banging on the doors as they hunted Pence and Pelosi. We spoke to a member of the Speaker's staff who had been blockaded in the room on that day. We stood on the east front of the Capitol, looking across the plaza at the Supreme Court, its white marble lit up in the dark night, as members of the Capitol Police described the breach of the doors. We walked through the rotunda and statuary hall toward the doors of the House chamber, following the same route the mob had taken on January 6th. We heard how the violent rioters had moved down the hallway around the House chamber and violently attacked the doors at the Speaker's lobby, shattering the glass and attempting to break through as House members and staff were being evacuated. Until you have walked the halls in this way, it is difficult to fully understand how close the violent rioters came to Vice President Pence, and indeed to many of us. Until you have heard it firsthand from the Capitol police officers involved, it is difficult to understand how profoundly the violence affected them, and how angry these officers are with members of Congress who try to downplay everything that happened. On the one-year anniversary of the attack, there was a small ceremony and a moment of silence on the floor of the House of Representatives. My dad came with me to the Capitol that day. We walked into the House chamber and took 2 seats in the front row on the Republican side. As we sat down, my dad looked over his shoulder at row after row after row of empty seats. We were the only Republicans there. Shaking his head, he said to me, "It's one thing to hear about what's happening in our party, but to see it like this in such stark terms." His voice trailed off. It was a profoundly sad moment. A few weeks later, the Republican National Committee, or RNC, convened for its winter meeting. They adopted a resolution censuring Adam Kinzinger and me. in a statement referring to the January 6th investigation as, quote, the persecution of ordinary citizens engaged in legitimate political discourse. The RNC accused Kinzinger and me of engaging in, quote, behavior which has been destructive to the institution of the U.S. House of Representatives, the Republican Party, and our republic. The resolution reflected a political party that had lost its principles and, frankly, seemed to be led by morons. This was my reply. The leaders of the Republican Party have made themselves willing hostages to a man who admits he tried to overturn a presidential election and suggests he would pardon January 6 defendants, some of whom have been charged with seditious conspiracy. I'm a constitutional conservative, and I do not recognize those in my party who have abandoned the Constitution to embrace Donald Trump. History will be their judge. RNC Chair Ronna Romney McDaniel immediately found herself having to explain how Republicans could possibly view the events of January 6th as legitimate political discourse. At one point, McDaniel said her principal concern was the committee subpoenas that had gone out to 16 Michigan Republicans, all of whom had signed a fake electoral slate, falsely certifying President Trump as the election winner. 2 years later, Michigan Attorney General Dana Nessel indicted those same 16 individuals for participating in the fraudulent scheme. As the committee's investigation would show, McDaniel had been involved in helping facilitate President Trump's and John Eastman's fake electors scheme. Not too long ago, the Republican Party had been the party of Ronald Reagan. George W. Bush and my father were the last Republican candidates to win the popular vote in any presidential election. And that was 2 decades ago, in 2004. It was no wonder why. In the aftermath of January 6th, Ronna McDaniel was either unable or unwilling to stand up to Trump. Instead, she apparently agreed to have the party pay Trump's legal bills and go along with everything else he wanted. In the choice between the Constitution and Donald Trump, the leaders of the Republican Party were turning away from the Constitution. 38, taking the fifth. As we moved toward winter, our teams of investigators were conducting an increasing number of witness interviews. Fairly early on, Democratic Congresswoman Zoe Lofgren and I realized that certain committee interviews had not been recorded on video, even when conducted over Zoom. We instructed that a video recording must be made of every interview. Both Zoe and I knew we had to consider the reality of our task. Reading the transcripts of witness interviews into the record in a televised hearing was unlikely to be effective. We needed the public to see the witnesses on camera. This might have been the first time that Zoe and I began to discuss in detail how the investigation should play out. Over the course of the investigation, as our committee discussed and debated important issues, Zoe and I almost always saw eye to eye. Although we likely didn't share many views on politics or public policy, we concurred about the gravity of the matters we were investigating and the responsibility we had to present our work effectively without spin or partisanship. In January 2022, our team composed a series of letters, followed by subpoenas, seeking cooperation from key witnesses. These letters explained in detail why their testimony would be relevant. Witnesses were well aware of our recent efforts to pursue criminal contempt against Steve Bannon, Mark Meadows, and others. These letters were intended to demonstrate that we had more than enough information to take the same course again. And we also wanted the Department of Justice to understand the evidence we had already developed. The DOJ had been exceptionally busy prosecuting the rioters, but we had not yet seen any clear indication that the department's investigation was turning to the topics we were covering. Many of our letters served their purposes. Several key witnesses cooperated quickly, and we made real progress. However, some individuals who had direct contact with Donald Trump did everything they could to resist providing testimony. John Eastman, for example, was the Chapman University law professor who had worked with Trump on the plan to overturn the election. Our investigation showed that Eastman himself did not believe Trump's plans to be legally defensible. Indeed, Eastman admitted that the Supreme Court would rule 9-0 against Trump if it heard the case. When Eastman had appeared on Tucker Carlson's Fox News show on December 6, 2021, Carlson suggested that Eastman could simply refuse to comply with the committee's subpoena. Obviously, Carlson said, we can't comply with this. The country does not belong to Benny Thompson, Nancy Pelosi, and Dick Cheney's daughter. Despite what Tucker said, Eastman came in for an interview on December 9, 2021. But he invoked his Fifth Amendment privilege against self-incrimination 100 times, including in response to questions about his direct discussions with Donald Trump. Jeffrey Clark, the DOJ lawyer who had met with Donald Trump repeatedly, also came in and took the Fifth. Like Eastman, Clark invoked the Fifth regarding questions about his communications with Donald Trump. General Mike Flynn, who met and spoke with Trump numerous times in the run-up to January 6th, including on December 18th and perhaps afterward, likewise pleaded the Fifth regarding his direct communications with Donald Trump. Flynn even took the Fifth when I asked him if he believed in the peaceful transition of power in the United States. Political operative and convicted felon Roger Stone, who also apparently had conversations with Trump, also took the Fifth in response to questions about those communications. All in all, dozens of witnesses took the Fifth in the course of our investigation. During the attack on January 6th, House Republican leader Kevin McCarthy had talked to Donald Trump, as had Jim Jordan. Both men refused to comply with committee subpoenas. So did Pennsylvania Congressman Scott Perry, who had talked to Trump repeatedly about the issues we were investigating. Mark Meadows, Dan Scavino, Steve Bannon, and Peter Navarro had each talked to Donald Trump about January 6th, and each of them refused to testify before the January 6th committee. The House of Representatives voted to hold them in criminal contempt. These four had chosen to risk criminal charges rather than discuss their interactions with Donald Trump. Testimony obtained by the committee suggested that Meadows may have contacted both Flynn and Stone at Donald Trump's request on the evening of January 5th. Flynn and Stone had both been photographed with certain members of the Oath Keepers or Proud Boys. Of course, members of both the Proud Boys and Oath Keepers were directly involved in the attack on the Capitol on January 6th, and a number of the leaders and members of these groups have since been convicted of seditious conspiracy. We also learned that in the midst of the violence on January 6th, members of the Oath Keepers were texting one another about Republican Congressman Ronnie Jackson of Texas. One text said this: Ronnie Jackson, office inside Capitol. He needs Oath Keeper help. Anyone inside? Another text read, Dr. Ronnie Jackson on the move, needs protection. If anyone inside, cover him. He has critical data to protect. Even Stuart Rhodes, the Oath Keepers leader who would later be sentenced to 18 years in prison for seditious conspiracy, texted about Jackson. Give him my cell. Ronnie Jackson had served as physician to President Trump before being elected to Congress in November 2020. He had attended President Trump's January 6th speech on the Ellipse. But when the Select Committee asked Jackson to appear for an interview to explain why the Oath Keepers had been talking about him by name during the attack, he refused. Instead, he said publicly that he had no idea how the Oath Keepers would have known him or why they texted about him. And yet the texts regarding Representative Ronnie Jackson did not simply appear from nowhere. Something triggered the exchanges. As far as I know, the committee found no similar texts among the Oath Keepers relating to the safety of any other member of Congress. Was someone communicating with the Oath Keepers about Jackson? Who exactly was that person? And finally, what was the critical data that Jackson supposedly had to protect? If anyone can get to the bottom of these questions, it will be Special Counsel Jack Smith. 39. The illegality of the plan was obvious. Although John Eastman had invoked the Fifth Amendment and claimed other privileges, The committee believed it was legally entitled to his emails and other communications. Under what is known as the crime fraud exception to attorney-client privilege, certain of those documents could be available if they provided evidence of what was likely a criminal or fraudulent scheme to overturn the election. We knew that John Eastman had communicated from an email account administered by Chapman University. Chapman had parted ways with Eastman about a week after January 6th, announcing that Dr. John Eastman will retire from Chapman effective immediately. John Wood and our investigative team believed that Chapman University might agree to turn over Eastman's email communications in response to a committee subpoena, but that Eastman might then file suit to prevent the college from doing so. We subpoenaed Chapman University, and sure enough, Eastman sued both the committee and Chapman in federal district court in California. Almost at once, we recognized that Eastman's suit could be pivotal. But to receive these supposedly privileged emails, we needed to convince the federal court that Eastman and Trump were involved in what was likely a criminal or fraudulent scheme. Phil and I had already been discussing these issues in great detail with committee lawyers John Wood and Joe Maher, including which potential criminal statutes might apply, given the evidence the committee had already developed. Our team worked closely with the House Counsel's Office, which did an excellent job in this case, to compile and present our voluminous evidence to the court and file our briefs in very short order. With the committee evidence in hand, federal judge David Carter conducted what is known as an in-camera review of John Eastman's Chapman University emails. We did not know then exactly what was in these emails, but Judge Carter reviewed them all and reached some stark conclusions. Judge Carter's decision began with a general description of the evidence. In the months following the election, numerous credible sources, from the president's inner circle to agency leadership to statisticians, informed President Trump and Dr. Eastman that there was no evidence of election fraud. This, of course, is the same conclusion now found in Special Counsel Jack Smith's August 1, 2023 indictment of Donald Trump. Judge Carter then turned to Donald Trump's efforts to overturn the election, identifying Trump's effort to install Jeffrey Clark as Attorney General, numerous attempts to persuade state officials and legislatures to alter the election results, and a plan, coupled with sustained pressure on Vice President Pence, to ensure that certified slates of electoral votes in several key states would not be counted on January 6th. The decision reached specific conclusions on the crime fraud exception. First, Judge Carter addressed the same provision of criminal law that I had referenced in support of our contempt resolution for Mark Meadows, 18 U.S.C. Section 1512C. The court's opinion said this: President Trump attempted to obstruct an official proceeding by launching a pressure campaign to convince Vice President Pence to disrupt the joint session on January 6th. The illegality of the plan was obvious. Our nation was founded on the peaceful transition of power, epitomized by George Washington laying down his sword to make way for democratic elections. Ignoring this history, President Trump vigorously campaigned for the vice president to single-handedly determine the results of the 2020 election. As Vice President Pence stated, no vice president in American history has ever asserted such authority. Every American, and certainly the President of the United States, knows that in a democracy, leaders are elected, not installed. With a plan this bold, President Trump knowingly tried to subvert this fundamental principle. Based on the evidence, the court finds it more likely than not that President Trump corruptly attempted to obstruct the joint session of Congress on January 6, 2021. The committee's briefing had also focused on another section of the criminal code, 18 U.S.C. Section 371, which makes it illegal to conspire to defraud the government through deceitful or dishonest means by obstructing the counting of electoral votes. Here were the court's conclusions on that provision. President Trump and Dr. Eastman participated in numerous overt acts in furtherance of their shared plan. As detailed at length above, President Trump's acts to strong-arm Vice President Pence into following the plan included meeting with and calling the vice president and berating him in a speech to thousands outside the Capitol. Dr. Eastman joined for one of those meetings, spent hours attempting to convince the vice president's counsel to support the plan, and gave his own speech at the Ellipse, demanding the vice president stand up and enact his plan. Based on the evidence, the court finds that it is more likely than not that President Trump and Dr. Eastman dishonestly conspired to obstruct the joint session of Congress on January 6, 2021. In specific response to John Eastman's argument that he was operating under a, quote, good faith legal theory, the court concluded, Dr. Eastman's views on the Electoral Count Act are not, as he argues, a good faith interpretation of the law. They are a partisan distortion of the democratic process. His plan was driven not by preserving the Constitution, but by winning the 2020 election. Dr. Eastman acknowledged that he didn't think Kamala Harris should have that authority in 2024. He didn't think Al Gore should have had it in 2000. And he acknowledged that no small government conservative should think that that was the case. Dr. Eastman also understood the gravity of his plan for democracy. He acknowledged, quote, you would just have the same party win continuously if the vice president had the authority to just declare the winner of every state. The evidence shows that Dr. Eastman was aware that his plan violated the Electoral Count Act. Dr. Eastman likely acted deceitfully and dishonestly each time he pushed an outcome-driven plan that he knew was unsupported by the law. After laying out all of these specific findings, the court reached a final conclusion. Dr. Eastman and President Trump launched a campaign to overturn a Democratic election, an action unprecedented in American history. Their campaign was not confined to the ivory tower. It was a coup in search of a legal theory. If Dr. Eastman and President Trump's plan had worked, it would have permanently ended the peaceful transition of power, undermining American democracy and the Constitution. If the country does not commit to investigating and pursuing accountability for those responsible, the court fears January 6th will repeat itself. As far as I know, this ruling is the first time that any congressional investigation has successfully invoked the crime fraud exception in federal court. 40. Trump thought Pence deserved to be hanged. While we were pleased with the federal court's Eastman ruling, it was difficult to understand why the Justice Department still had not taken any action with respect to Mark Meadows and the criminal contempt resolution against him. By March 2022, we had been waiting 3 months for the Justice Department to indict Meadows for contempt of Congress. It should have been an easy case. Meadows had produced documents to us, including his text messages. We were entitled to question him about those documents. None of that material could conceivably be privileged. For months, January 6th committee staffers had been fielding questions from DOJ lawyers who were compiling a record to support a Meadows indictment. Our committee's investigatory team was convinced that justice would indict Meadows and that it would happen soon. Indeed, they believed that justice lawyers had recommended such an indictment up the chain at the department. Justice had indicted Steve Bannon only a few weeks after our contempt vote, so we were now growing understandably frustrated. Recognizing that time was running out before our upcoming hearings, I concluded that we could no longer wait for the Justice Department to act. We would need to adopt a different approach. I had publicly cited several key reasons why we needed Meadows' testimony, but we had other reasons I did not mention at the time. Mark Meadows had written a book entitled The Chief's Chief that was published in December 2021. It contained a number of intentionally false descriptions about what had happened on January 6th. Indeed, the book was so obsequious that it could have been dictated to Meadows by Donald Trump himself. Some on our investigative team even believed the chief's chief was an attempt to communicate the company line for other witnesses to follow. Today, the book is famous for another reason. The Justice Department indictment against Donald Trump for obstruction of justice and unlawfully retaining national security documents at his Mar-a-Lago retreat in Florida relies in part on an audio-taped meeting between Trump and the ghostwriters for Meadows' book. Here is just one example of a deliberate Meadows falsehood from the book. Meadows claimed that Donald Trump had ordered 10,000 National Guard troops to be on standby for January 6th. Meadows also suggested publicly that Donald Trump had given an order to deploy those troops. But when asked if that statement was true, Acting Secretary of Defense Chris Miller told the committee under oath, quote, "Not from my perspective. I was never given any direction or order or knew of any plans of that nature, so I was surprised by seeing that publicly." Pressed again on whether Trump had ordered those 10,000 troops to be ready, the former acting secretary said, quote, "There was no order from the president." As we later showed in detail during committee hearings, President Trump did not want to ask the violent rioters to leave the Capitol, and he refused for multiple hours to go on the air and instruct them to leave. It seemed absurd to us that Donald Trump would argue that he had dispatched the National Guard to forcibly remove the rioters from the Capitol, when for 3 hours he would not take even the most elementary step of asking the rioters to stand down and leave. Meadows made numerous other intentionally false claims, including that Donald Trump never intended to travel to the Capitol with the crowd on January 6th. Donald Trump, of course, announced his intention during his ellipse speech that day. Meadows claimed that Trump had told him he was speaking metaphorically. Again, not true. Multiple witnesses testified that Trump was adamant about going to the Capitol, and that he got very angry when told he could not go. In addition to what witnesses disclosed, I had personally received other information that led me to believe Meadows was concealing the facts. For more than 7 years after the attacks of September 11, 2001, I had been a Secret Service protectee. I kept in touch with a number of the men and women who had protected our family during that time. During the course of the January 6th investigation, I had contact with certain of the agents who had been on our details. At one point, it was suggested that our investigation should look closely at what happened when Donald Trump got in the presidential vehicle, leaving his ellipse speech around 1:10 p.m. on January 6th. We did. My understanding was that many agents had heard, either through chatter with their colleagues or otherwise, that President Trump was very angry when he was told he could not travel to the Capitol that afternoon, and that something had happened inside the presidential limo. Thus, even before we began questioning White House witnesses, I had reason to believe the statements in Meadows' book were untrue. Back in December of 2021, the day after Meadows had announced he would not attend our scheduled interview, he sued the January 6th committee in federal district court in the District of Columbia. Meadows' suit raised all sorts of arguments. One of them was that, as a former president's former chief of staff, he was protected from testifying by executive privilege and by a doctrine of absolute immunity. Meadows' suit gave us another opportunity. We could file a motion for summary judgment with the court, asking the judge to issue a ruling that Meadows' arguments were wrong on every front. This would remove any legal shield Meadows thought he might have to avoid testifying. After all, we had already litigated and won on Donald Trump's executive privilege arguments. This idea was debated with the House Counsel's office. House Counsel had been reluctant since the fall of 2021 to bring any civil case to enforce our subpoenas. If we lost, the argument went, it would create a bad precedent for the House as an institution. I argued that we could not throw in the towel. Our investigation was more important than any risk of a bad ruling. Giving up would only show weakness. At this point in the investigation, the January 6th committee still had many witnesses to pursue, and I was concerned about any public perception that our resolve was weakening. I could explain litigating and losing about Meadows. I could not explain failing to even try to secure the testimony we needed. Speaker Pelosi supported my view. I prevailed in the debate, and we filed summary judgment briefs detailing the facts that supported our arguments. We also filed specific evidence from the committee's interview transcripts related to Mark Meadows' actions on and before January 6th. Some of this evidence came from interviews of Mark Meadows' principal aide in the White House, a woman named Cassidy Hutchinson. Alyssa Farah Griffin had initially alerted us that Hutchinson could be a key witness. While we did not know this at the time, we learned later that the detailed, factual material we had filed in our briefs in the Meadows case had an immediate impact on Cassidy. By that point, Cassidy had sat for only 2 of the many interviews we would ultimately conduct with her. Cassidy had worried from the moment she agreed to be represented without charge by a Trump-affiliated lawyer. She sought advice from a Republican member of Congress not on the Select Committee, and he had cautioned Cassidy, "I want you to know that you can't take money like that and expect them to just be working for you and your interests," implying that the Trump lawyers representing her would have Trump's interests in mind. When Cassidy read our brief in the Meadows case, she realized what had happened. Here's how she described it to the Select Committee. "So I just searched my name, and I see that there are citations from my transcript, both of my transcripts. So I'm reading through them, and then I read through them again and again and again, and I just kept thinking, oh my God, I became someone that I never thought I was going to become." Cassidy also told the Select Committee that shortly after she read this material, she talked to Alyssa Farah Griffin about her situation. "Alyssa, I know you know I had a Trump world attorney. I don't think I have to go into excruciating detail to tell you the situation I'm in right now. But I think that I should go in and elaborate on a few things. I think I need to go in and kind of expand on some things." Alyssa called me in April 2022. She said she had spoken to Cassidy and that Cassidy had additional information she wanted to share with the committee. Alyssa gave me examples of the information. She said that on January 6th, Cassidy had heard Meadows and others saying President Trump believed Mike Pence deserved to be hung in response to the mob chants of "Hang Mike Pence." And Cassidy had observed Mark Meadows burning documents in the fireplace of his West Wing office on a number of occasions. Alyssa also said that Cassidy was concerned about the Trump-funded lawyer who was representing her. I shared this information with the committee counsel who had led Cassidy's initial interviews, and we discussed the right approach to take. Through Alyssa, Cassidy was approaching the committee directly. Although Congress is not required to recognize attorney-client privilege for any witness, we did not want to obtain testimony addressing the events at the heart of our investigation without a witness's counsel present. I told Alyssa that we would like to speak with Cassidy again, but that we could speak with her about the substance of our investigation only if both the committee counsel and her own counsel were present, and we wanted her testimony to be on the record. Our committee counsel called Cassidy's lawyer to set up a new interview. In the meantime, we discovered that the predictions made by our committee staff about the Department of Justice were wrong. The Justice Department announced that it would not indict Meadows for contempt. We were guessing that senior Justice Department officials felt constrained by the legal concept called absolute immunity, the same doctrine that Meadows had asserted to avoid testifying before us in December of 2021. Presidential staff often cite absolute immunity when they negotiate what testimony White House officials can and cannot give before Congress. The concept, however, has been subject to significant debate. We were not aware of any precedent supporting Meadows' claim that a former chief of staff to a former president is categorically immune from giving congressional testimony. As the Meadows case wore on, U.S. District Court Judge Carl Nichols asked the Department of Justice to file a brief about whether Meadows was entitled to absolute immunity. When the Justice Department brief was filed, we learned that the department was not applying absolute immunity to Meadows. Justice had concluded that only the more lenient concept of qualified immunity applied. They explained further that the January 6th committee's need for Meadows' testimony outweighed and therefore overcame any qualified immunity arguments Meadows might have. In other words, immunity could not protect Meadows from testifying before our committee. So why had the Justice Department refused to indict Mark Meadows for contempt of Congress? We were seeking to ask Meadows about his texts and other materials that could not be subject to any privilege claim. It made very little sense for Justice not to indict, unless, some suggested, Meadows had started cooperating with the Justice Department in its own January 6th investigation of President Trump. Had our criminal contempt referral pushed Meadows into cooperating with the Department of Justice? We did not know. But we did know from Cassidy Hutchinson that Mark Meadows probably had many important pieces of information to share with the department. The speculation about Meadows was also fueled by the fact that he had abruptly halted his appearances on Sean Hannity's Fox News show. Indeed, he seemed to have dropped from public view entirely. By September 2023, there were press reports that Mark Meadows had now testified before the January 6th grand jury. Meadows' testimony could have been exceptionally helpful to the Select Committee. The public deserved to hear from him. We hoped that the Justice Department had a very good reason for its decision not to indict him for contempt. 41. To the best of my recollection, I don't recall. As our investigation progressed and our skilled committee staff questioned dozens of additional witnesses, I often joined portions of the questioning. This was especially the case for high-ranking members of the Trump administration. I wanted to pose fundamental questions about the duties of a president and the rulings of our courts. I also wanted to understand each witness's personal interactions with President Donald Trump. The public later saw many of these exchanges in our hearings. We knew that Attorney General Bill Barr had told Donald Trump forcefully and repeatedly that there was no evidence to substantiate Trump's election fraud claims. Acting Attorney General Jeff Rosen and his deputy Rich Donahue had also done so repeatedly, as had Trump campaign officials, as had Trump White House staff. As the interviews accumulated, it became clear that Donald Trump was hearing a consistent drumbeat. A number of his advisors, it appeared, had reached the same set of conclusions independently, without consulting one another. It also appeared that many of these staff members believed the information they were giving Trump would eventually sink in, that he would slowly conclude he must give up and concede the election. Consider this example from Attorney General Bill Barr's testimony about a meeting on November 23, 2020. As I walked out of the Oval Office, Jared was there with Dan Scavino, who ran the president's social media, and who I thought was a reasonable guy. And I said, how long is he going to carry on with this stolen election stuff? Where is this going to go? And by that time, Meadows had caught up with me and said, look, I think that he's becoming more realistic and knows there's a limit to how far he can take this. And then Jared said, yeah, we're working on this. We're working on it. Although Jared's statement to a concerned Bill Barr tended to suggest that Kushner was pushing his father-in-law to the right outcome, other testimony indicated that Kushner was also assisting Trump's very successful efforts to spread to the public what virtually everyone in the White House knew to be election lies. When we asked Jared if he had played any role in organizing Trump's advertising campaign to disseminate the election lies, he said, yeah, I was a creative director, so that's a fair assumption. I wanted to know why Jared had not done more to stop January 6th. Jared told the committee that he had been busy with pardons in December 2020 and with issues in the Middle East. Donald Trump pardoned Jared Kushner's father, Charles Kushner, on December 23rd, and Jared appears to have left for the Middle East around January 4th. At one point in my questioning of Jared, he recited one of his favorite quotes about Trump. Jared said, I forget the journalist, but she said that the media took Trump literally but not seriously, and the voters took him seriously but not literally. I had the impression Jared thought this was clever. But the problem with Jared's quote is this. Tens of millions of American voters actually took Trump's election fraud allegations literally. They did not see the allegations as some kind of clever parody. And hundreds of Trump supporters have now pled to or been convicted of criminal acts. sacrificing their freedom to achieve what they believed Donald Trump asked them to do. People died, and scores of police officers were seriously injured. Jared's clever quote implies that Trump was knowingly playing a cynical game the entire time, intentionally misrepresenting the facts for his own purposes. Of course, there is already substantial additional evidence that Trump was acting intentionally, making false statements to motivate his supporters and, of course, to raise money from them. I had met both Jared Kushner and his wife Ivanka several times, but I did not know either of them well. Today, they appear to be trying to distance themselves from Donald Trump's January 6th conduct. Perhaps they privately acknowledge that Trump spun completely out of control over the last few months of his administration. They should have done much more to stop him. Before the investigation into the attacks of January 6th, I had not been sure exactly what to make of White House Press Secretary Kayleigh McEnany. I'd seen her press conference on the morning of January 7th. It appeared then that she was distraught and had not slept. I thought at that moment that Kayleigh might be having some real problems trying to deal with what had occurred. The evidence shows that, in the days after January 6th, Kayleigh worked to rein in Donald Trump. She cooperated with Sean Hannity and a team of others to try to contain Trump's actions, to isolate him, so he could not again take us off a cliff. But when Kayleigh came in to testify, she seemed overly coached, evasive, and at times combative. Some of her answers, however, were accurate and careful. For example, when I asked Kayleigh if she agreed that the president was bound to accept the rulings of the courts, she agreed. I asked Ivanka Trump the same thing. She agreed as well. But we thought Kayleigh McEnany had been carefully coached not to reveal certain key details, including those already furnished to the committee by her deputy, Sarah Matthews. When I asked Kayleigh about some of those details, she responded this way. For a senior official, or for a press secretary who's in the middle of a crisis, conversations with lower-level staffers might not stand out to me. We all thought this was a rehearsed answer. We had evidence that the White House and President Trump himself had been alerted to the violence almost immediately after it began. I was therefore surprised that Kayleigh, as the press secretary, was taking the position that she did not immediately know about the violence, when many others who interacted with her in the White House did. A couple of times during her interview, Kayleigh's attorney coaching seemed to lead her to say things like, "To the best of my recollection, I don't recall." Ultimately, I concluded that Kayleigh McEnany was trying very hard to avoid saying anything that might anger Donald Trump. This was the opposite approach from that taken by witnesses such as former White House counsel Pat Cipollone. As our investigation progressed further, and it became ever more apparent that the committee possessed very detailed information about what had happened in the White House, the strategy of lawyers defending Trump allies began to change. Kayleigh was one of our first senior-level White House witnesses. If she had testified after seeing Pat Cipollone's forthright testimony, I suspect she would have supplied very different answers. Even so, Kayleigh seemed to acknowledge that Donald Trump should have instructed the rioters to leave the Capitol much earlier in the day. And as the interview wore on, she sometimes dropped the lawyerly answers and expressed her genuine thoughts. I asked her, "Do you believe what happened on January 6th was justified?" And she responded, "Absolutely not. What happened on January 6th was not justified. I condemn violence in every form. I am a Christian. I believe in Jesus Christ. I believe in peace. I love people on the other side of the aisle. Whether they're Biden voters, Kamala supporters, that's who I am. I'm a good-natured person. Absolutely, it was not justified." Ultimately, we received highly credible testimony from multiple witnesses with firsthand knowledge on almost all the key issues. All Americans can comb through the transcripts of our interviews, which we released online, and reach their own judgments. By late April of 2022, our highly professional committee staff had pieced together a fair amount of the factual predicate that we would ultimately need for our hearings. But we were still concerned about key gaps in our knowledge, gaps that we now set out to fill. 42. Not the mastermind. In the spring of 2022, a handful of staff leaks also became a very significant concern. On April 25, 2022, thousands of Mark Meadows' text messages were leaked to CNN. I believed that one particular staff member who announced his departure from the committee the same day had leaked the material. The leak was unethical and counterproductive for our investigation. While I hoped that most of the team, including most of those who had spent their careers laboring under the strict rules that apply to federal prosecutors, knew the damage that leaks could cause, we sadly now had to begin to close the circle of those with access to investigative information. We also occasionally had to contend with staff recommendations that we take investigatory steps that did not seem justified by the evidence before us. One memorable example related to Supreme Court Justice Clarence Thomas. A committee staff member had identified electronic communications from an email address that included the letters CTIII and concluded that the communications must have originated from Justice Clarence Thomas. The staff member who made that determination, which he later admitted had been erroneous, did not have any legal training. Otherwise, he would have recognized that no Supreme Court justice could have drafted the various items in the emails. But he made an incredibly aggressive proposal to subpoena all of Justice Thomas's private communications in multiple forms of media. It ultimately turned out that the email address belonged to someone else, a former Republican staffer in North Carolina, who felt strongly about election fraud allegations. When that mistake came to light, some staff members who had been very interested in pursuing Justice Thomas recognized that this could have been a horrendous mistake. It was lucky that we were being careful. Although our investigation never found communications that genuinely came from Justice Thomas, we did find text messages and other communications from his wife, Ginny. I had known Ginny Thomas for decades. By the time we were investigating January 6th, I had not spoken to her for some time. I never thought of Ginny as a leader of any conservative group or movement. She was usually assisting someone else. I thought that others tried to use Ginny's notoriety to gain support for their own causes. I suspected she might have fallen into some role supporting the January 6th effort. But from my knowledge of her, I doubted very much that she was a mastermind of any of it. Although we had been friendly in the past, Ginny had been attacking my involvement in the January 6th committee ever since I joined it in July of 2021. In December 2021, she signed a public letter urging that, quote, the House Republican Conference act immediately to remove both Representative Liz Cheney and Representative Adam Kinzinger due to their egregious actions as part of the House of Representatives' January 6th Select Committee. I was amused when liberals in the press or on social media accused me of favoritism toward Ginny. As Phil put it, I guess they haven't Googled what she's been saying about you. I ignored what Ginny Thomas was saying publicly about me. My view was that Ginny should be treated in the same way as every other witness who had engaged in similar conduct, no better and no worse. After some discussion, the committee composed a letter to Ginny Thomas with that message, and she ultimately agreed to a recorded interview. The transcript of that interview, conducted by professional staffers, with additional questioning by a number of members, including Adam Schiff, Jamie Raskin, Pete Aguilar, and me, was released by the committee. Here is a typical exchange. I asked Ginny Thomas, and so, are you aware that the president and his allies brought legal challenges, which was completely their right to do, but that they lost 61 out of 62 of those legal challenges? She replied, I still believed that there was fraud and irregularity, as millions of Americans do, Representative Cheney. I was disappointed that Ginny Thomas had been deceived by the demonstrably untrue election fraud nonsense. I was even more concerned that she did not seem to respect the rulings of our courts. Ginny, like many others, seemed to believe everything she read and saw in the Trump-friendly media. She was asked on a couple of occasions if she might have had a different view had she known that Donald Trump's advisors were privately telling him his fraud claims were unfounded. At first, she replied that it wouldn't have changed her views, that she had believed what she was hearing from friends and seeing on the news. Eventually, she just answered, "I don't know." At one point during the investigation, Chairman Benny Thompson gathered the committee at the Library of Congress for a day-long planning session. We met in a conference room on one of the top floors overlooking the Capitol. We spent the day working through our upcoming interviews and discussing next steps for the investigation. Perhaps the most memorable event from that day is what we did during an afternoon break. Chairman Thompson led us down 2 floors to the rare book reading room, where Library of Congress scholars had brought out some of the most important and meaningful documents in the library's holdings. We stood together, Republicans and Democrats, looking down at a copy of the Gettysburg Address on yellowing paper, written in pencil by Abraham Lincoln himself. We saw Alexander Hamilton's handwritten notes detailing the flaws of the Articles of Confederation, and a copy of Washington's farewell address, warning of the danger of political factions, exactly what we were dealing with now. We saw Thomas Jefferson's copy of the Manual of Parliamentary Practice, which to this day still forms the basis for rules and procedures in the House of Representatives. And we saw a note written by Lincoln on August 23, 1864, when he thought he was likely to lose the upcoming presidential election to General George B. McClellan. If McClellan prevailed, Lincoln believed McClellan would seek an armistice with the Confederacy, essentially recognizing the independence of the Confederate States. Lincoln wrote in part, "This morning, as for some days past, it seems exceedingly probable that this administration will not be reelected. Then it will be my duty to so cooperate with the President-elect as to save the Union between the election and the inauguration, as he will have secured his election on such grounds that he cannot possibly save it afterwards." When he finished writing it, Lincoln folded the note, sealed it, and took it into a cabinet meeting. He asked each member of his cabinet to sign the outside of the document. The memo was Lincoln's pledge to respect the will of the people and the outcome of the election, and to do everything in his power to help his successor if he lost. The note was also a reminder of how monumentally critical Lincoln's reelection was. Everything depended upon it. Part 5, The Relentless March of Evidence, May to December 2022. 43, 7-part plan. Throughout the spring of 2022, Phil and I had been considering how to organize the hearings. We knew the significant challenges. What Donald Trump and his allies had done from Election Day to January 6th was far-flung and detailed, and would be difficult to address in any concise fashion. There were dozens of presidential calls and meetings supporting all of Trump's efforts. Indeed, the planning for January 6th appears to have consumed the vast majority of the president's time for several weeks in December of 2020. He was doing almost nothing else. Donald Trump did not do all this on a whim. It was not something planned in 1 hour, or in 1 day, or even in 1 week. It was complicated and detailed. And above all else, it was premeditated. As summer approached, Phil and I created an outline for the upcoming hearings, using large poster paper tacked to the walls of my home office. It was an exercise we had both engaged in many times before, in preparation for trials, Phil, or political and legislative debates, me. We needed to subdivide our presentations into segments, making the content easily digestible by a television audience tuned in to a series of congressional hearings. And we needed to distill an enormous level of detail into something that could be readily understood. Our solution was to divide the factual material into 7 parts, and therefore at least 7 hearings. Each would highlight a distinct element of the Trump team's efforts to overturn the 2020 U.S. presidential election. First, we knew we had to begin with Donald Trump's successful effort to persuade millions of Americans that the election had somehow been stolen from him, that he was still, for that reason, the rightful president. Thanks to what our investigation had uncovered so far, we knew that Trump had been told repeatedly, by his campaign, by his Justice Department, and by his White House staff, that none of his stolen election claims were true. This had to be the focus of an early hearing, because those lies were the foundation for everything that followed. Second, we also now knew, again thanks to the work of our investigative staff, how Donald Trump had tried to pressure state legislatures and state officials to flip official certified Biden electoral votes to Trump. Third, our staff had also uncovered significant evidence showing how the Trump team had created fraudulent Trump electoral slates for states that Biden had won. Both of these efforts, the vote flipping and the slate fabrication, were key elements of the Trump plan. Fourth, when Trump's plot to convince state legislatures to flip the electoral votes did not work, Trump began looking for a way to make the U.S. Justice Department persuade those legislatures to do so. Trump offered an official named Jeffrey Clark the job of acting attorney general after others at Justice refused to spread Donald Trump's stolen election lies, because Clark was amenable to Trump's schemes. Again, another part of the plan. Fifth, the Trump team planned each of those steps with the January 6th joint session of Congress in mind. The intent was that Vice President Pence, in his formal role as President of the Senate, would agree on January 6th not to count the official Biden electoral votes from multiple states, and Pence would rely on the fraudulent Trump electoral slates as a rationale for doing that. Sixth, to further support what he planned for Mike Pence, Donald Trump summoned his supporters to Washington on January 6th, where he would stage an emotionally charged rally with slogans like "Take Back Our Country," before sending them to the U.S. Capitol. The crowd itself would apply the pressure needed to make all this work. Trump was well aware of the potential for violence by those tens of thousands of people, yet he went ahead with that part of his plan anyway. And seventh, the ultimate element of Trump's plan took shape as the crowd attacked the Capitol. Donald Trump was trying to delay the electoral count, but once it became clear that Mike Pence would not refuse to count genuine Biden electoral votes, Trump had few options remaining. As the crowd became violent, broke into the Capitol, and halted the joint session, the violent attack and the invasion of the Capitol were the only things stopping the electoral count. And it was at this point that Donald Trump refused to do what everyone knew was absolutely necessary. He refused for hours to instruct the rioters to stand down and leave, all while continuing to lobby legislators to stop the count. As a result, more than 140 law enforcement officers were attacked and injured, and 5 deaths eventually resulted. So these were the 7 principal elements of the Trump plan. We recognized that each hearing would require a careful, fact-based presentation, and each would rely on testimony from Republican officials and Republican witnesses. I began to work with Jamie Fleet, the House Administration Committee staff director, who was helping to facilitate operations of the January 6th committee, and Terry McCullough, the Speaker's Chief of Staff, to ensure we could get House Speaker Nancy Pelosi's buy-in for this hearing plan. A number of proposals were being considered, including holding a single hearing or combining all the material into 2 or 3 hearings. We knew that what we were doing was unprecedented and that we had to get it right. Our lead investigative staff had been assembling their most important evidence. Terry McCullough and Jamie Fleet arranged for them to present this evidence to Select Committee Chairman Benny Thompson and me in a series of meetings in May. We met in Fleet's office on the 3rd floor of the Capitol building with the committee's senior staff, Kristen Ammerling, David Buckley, Tim Heaphy, Joe Maher, Tim Mulvey, and Hope Goins, who served as senior counsel to the chairman, to review documents and hear from each of the committee's lead investigators. They presented segments of testimony from the depositions and interviews they had been conducting. They also provided a summary of the work they had completed to date, plus an assessment of their highest priorities moving forward. I had also spent weeks participating in interviews and combing through transcripts, and I worked with the committee's digital team to begin compiling video clips of what I thought was the key evidence for each part of Trump's plan and for each of the hearings. We had spoken at length with a couple of news programming veterans. One of these individuals recommended that we meet with James Goldston, the former president of ABC News. James came in to interview with Chairman Thompson and then met with me later that day in my hideaway office in the Capitol basement. I was impressed. James was humble, but obviously talented and experienced. He came on board and brought with him a number of individuals with years of experience in network news. As we began to structure each hearing, I recalled my experience as a Fox News contributor a decade earlier. On several occasions, I had been a substitute host for Sean Hannity on his primetime show. I remembered that those programs were organized in segments called blocks. An hour-long show was typically divided into 5 or 6 blocks. This structure proved to be an essential way of managing the immense amount of material in each hearing. James Goldston and his team were exceptionally helpful in facilitating that type of presentation, and our outline for each hearing, which took the form of a trial presentation, closely paralleled that structure. We also relied heavily on Tim Mulvey, the January 6th Committee's talented communications director, to help oversee the staff that pulled all the pieces together. He worked with Chairman Thompson on his remarks and was responsible for all aspects of our relations with the press. There was intense interest in the committee's work. We needed to ensure we did everything possible to prevent leaks and provide facts so the details and the truth would be accurately covered. In a traditional congressional hearing, each member of a committee is allocated 5 minutes to ask questions. We knew from the start of our process that approach would not work. All committee members agreed that the evidence, not the members, should be the focus of our hearings. This meant, however, that not every member would make remarks in every hearing. Over the course of several individual and group meetings, Chairman Thompson, with help from Jamie, Terry, and Speaker Pelosi, secured the agreement of all committee members for the format we ultimately used. Each hearing would have 1 or 2 members assigned to present the evidence. Chairman Thompson and I would each make an opening and closing statement. All members would attend every hearing, even if they were not presenting. Our first 2022 hearing was scheduled for June 9th. One goal of this hearing was to lay out a comprehensive outline for what was to come. The idea we settled on was that Chairman Thompson would first set the scene, describing the work the committee had done and the grave nature of the challenges we faced. He would also put this in the context of our nation's history. Then I would present a detailed roadmap for the hearings to come. Another goal of the first hearing was to remind everyone of the stakes, just how terrible the January 6 attacks had been, and why nothing like that must ever happen again. We would feature previously unseen video of the attack and testimony from at least one law enforcement officer explaining in even greater depth the violence of January 6th. While we were making those plans, I faced a crossroads of a different sort. I needed to decide whether to register again as a candidate for Congress in Wyoming. The filing deadline was May 27, 2022. I gave significant thought to not running for re-election. I had lost confidence in the House Republican leadership. I was disappointed in many of my colleagues, who were also my friends, many of whom told me they agreed with what I said, but would not step forward or speak out. I also knew I faced a huge uphill battle in Wyoming, but I had been humbled and grateful for the expressions of support I was receiving across the state. My work on the January 6th Select Committee was vitally important, but doing it well, ensuring that the investigation and our hearings were a success, demanded an enormous investment of time. It was time I would not be able to spend on the campaign trail in Wyoming. The easiest course, by far, would have been simply not filing to run again. But that didn't feel right. I'd received an outpouring of support from friends and allies across the state, men and women who were eager to help me win re-election because they understood what was at stake. These included some people who had always supported me, others who never had, and still others who had opposed me in previous races but had since become strong advocates. I did not want to abandon any of them. Withdrawing from the race for my seat in Congress would be seen as declaring defeat in my own election. It might also signal that our investigation had failed, that I was giving up, or that this fight somehow no longer merited the effort. I knew that the Trump team would claim my decision to quit as their victory. I sought the counsel of an old friend who had spent his career working on programs to promote democracy around the world. Since January 6th, we had met privately several times in a townhouse near Capitol Hill, along with a small group of experts on authoritarianism and the rise of anti-democratic movements. We agreed that the threat posed by Donald Trump might well imperil the existence of American democracy. My friend asked me, "Does withdrawing from your race make you stronger or weaker in confronting the threat Trump poses?" I thought for a minute before replying. "It weakens my hand." "Then you've got your answer," he said. When I considered the decision from every angle, standing with constituents who had stood with me, doing what was right for Wyoming and for the country, and making sure the January 6th committee had the best chance to effectively complete its work, the choice was clear. I might well lose my race, I knew, but I wouldn't quit. I filed to run for re-election. As the first of our 2022 hearings approached, Phil and I drafted my opening statement, following the 7-part structure we had created earlier, with clips of key evidence. The story needed to be told by Trump administration witnesses and members of the Trump campaign. Donald Trump's own words would convey his intent. I had shared my opening statement with a handful of people, including Joe Maher, Kara Ahern, and Jamie Fleet. Most committee members and staffers did not see it until our run-through the evening beforehand. Some members of the staff were concerned about the length and level of detail in my remarks, but I stood firm. I believed we owed the public a clear roadmap for where we were headed, and that an opening statement beginning to lay out our evidence was essential. Chairman Thompson and Speaker Pelosi agreed. A day before our hearing, Republican Representative Troy Nehls demonstrated just how craven certain Republican members of Congress had become. "They're going to get the sobbing police officer," Nehls predicted, or sobbing Democrat, or somebody that said how terrible this was, and now they're suffering from PTSD. Congressman Nehls must have been surprised when our hearing opened with clips from numerous senior Republicans who had worked for Trump and were now testifying against him. I hope Nehls was ashamed as he listened to Capitol Police Officer Caroline Edwards describe in detail what she faced while engaged in hand-to-hand combat to defend the Capitol. Our June 9th, 2022 hearing convened at 8:00 p.m. in the Cannon Caucus Room. As we took our seats on the dais, I looked out into the large, historic room. It was packed. Rows of journalists sat at long tables. Members of the Capitol Police and Metropolitan Police who had been wounded in the attack were in attendance. A group of members of Congress who had been trapped in the House gallery on January 6th were also present, as were family members of fallen Capitol Police officers Brian Sicknick and Howard Liebengood. Chairman Thompson opened the hearing with a vivid and moving statement about the oath we all take to the Constitution and the duty our oath imposes on us. He quoted from the letter we had seen at the Library of Congress a few months earlier. Lincoln's pledge to do all in his power to support his successor if he was defeated, to uphold the rule of law and guarantee the peaceful transfer of power. And he described Donald Trump's refusal to do the same, instead attempting to overturn the results of a presidential election in order to stay in power. I began my presentation with the issue I believed was central to everything we were doing. What exactly was Donald Trump's state of mind? What did he think he could accomplish on January 6th? For this, we used Donald Trump's own words. I began by describing his response to the attack.
Mr. Chairman, at 6:01 p.m. on January 6th, after he spent hours watching a violent mob besiege, attack, and invade our Capitol, Donald Trump tweeted, But he did not condemn the attack. Instead, he justified it. "These are the things and events that happen," he said, "when a sacred landslide election victory is so unceremoniously and viciously stripped away from great patriots who've been badly and unfairly treated for so long."
This is what Donald Trump said to our nation when the violence was freshest in our minds. Members of multiple law enforcement agencies were still attempting to halt the remaining fighting and clear the Capitol. We needed to convey, as accurately as possible, in his own words, the malignant state of mind of our former president. And as he walked from the Oval Office up to the White House residence not long thereafter, he commented only that he was angry with Mike Pence for letting him down. He voiced no regrets about what had already happened and was still happening at the Capitol. I explained that the committee's hearings would show that President Trump knew violence was underway and refused to tell his supporters to leave the Capitol.
As you will see in the hearings to come, President Trump believed his supporters at the Capitol, and I quote, "were doing what they should be doing." This is what he told his staff as they pleaded with him to call off the mob, to instruct his supporters to leave. Over a series of hearings in the coming weeks, you will hear testimony, live and on video, from more than half a dozen former White House staff in the Trump administration, all of whom were in the West Wing of the White House on January 6th. You will hear testimony that, quote, "the president did not really want to put anything out, calling off the riot or asking his supporters to leave." You will hear that President Trump was yelling and, quote, "really angry at advisors who told him he needed to be doing something more." And aware of the rioters' chance to hang Mike Pence, the president responded with this sentiment, quote, "maybe our supporters have the right idea. Mike Pence, quote, deserves it."
Then, after describing some of the evidence the public would see that evening, I began to focus on the structure of our presentations over the coming weeks.
Tonight, I'm going to describe for you some of what our committee has learned and highlight initial findings you will see this month in our hearings. As you hear this, all Americans should keep in mind this fact. On the morning of January 6th, President Donald Trump's intention was to remain President of the United States, despite the lawful outcome of the 2020 election and in violation of his constitutional obligation to relinquish power.
Our most immediate task was to show that Donald Trump's own advisors knew the election had not been stolen. Everything that had happened was premised on an outright lie. So I presented a series of excerpts from committee witness testimony from Donald Trump's campaign and his inner circle of advisors. First, we played Jason Miller, Donald Trump's campaign spokesman, testifying that he told Donald Trump in the days after the 2020 election that he had, in fact, lost. This was followed by clips and descriptions of Trump campaign lawyers saying that the allegations of election fraud were not real, that they could not change the outcome, and that Biden had won. We then played multiple clips of Donald Trump's Attorney General, Bill Barr, testifying that he had told Trump almost the exact same thing. None of this testimony had been seen by the public, and it had an immediate impact. Many Americans had heard that courts had ruled against Donald Trump, but few knew that Trump's own campaign leadership had been telling him he lost. We also realized this. The Trump campaign did not know exactly what Donald Trump was hearing from the Justice Department, while the Justice Department did not know exactly what Trump was hearing from his campaign. Both entities were, in fact, telling Donald Trump the same thing. His stolen election claims were bogus, and they were telling him this with specificity about each of the claims he was making. No rational human being could have heard all this information from multiple close advisors and still genuinely believed that the election was stolen. Trump lost. He knew it. Next, we played a clip of Donald Trump's daughter, Ivanka, confessing that she agreed with Attorney General Barr that her father had lost. I followed this with a description of the lawsuits that Donald Trump had lost, and a judicial ruling that Donald Trump's chief election fraud lawyer, Rudy Giuliani, quote, communicated demonstrably false and misleading statements to courts, lawmakers, and the public at large. And Giuliani had lost more than the lawsuits. His license to practice law had been suspended. The foundation for everything that happened on January 6th was entirely made up. All of Trump's ads and speeches about a stolen election were false. I walked through the specific evidence the committee would present about each element of Donald Trump's plan to overturn the 2020 election, explaining how each of the pieces fit together. Then I turned to the aftermath of the attack, including that Donald Trump's White House staff immediately recognized how bad January 6th had been and worked to isolate him so he could not do further harm in the 2 weeks before leaving office. I wanted people watching to understand just how dangerous this was.
When a president fails to take the steps necessary to preserve our union, or worse, causes a constitutional crisis, we're at a moment of maximum danger for our republic. Some in the White House took responsible steps to try to prevent January 6th. Others egged the president on. Others, who could have acted, refused to do so. In this case, the White House counsel was so concerned about potentially lawless activity that he threatened to resign multiple times. That is exceedingly rare and exceedingly serious. It requires immediate attention, especially when the entire team threatens to resign. However, in the Trump White House, it was not exceedingly rare, and it was not treated seriously. This is a clip of Jared Kushner addressing multiple threats by White House counsel Pat Cipollone and his team of lawyers to resign in the weeks before January 6th. Jared, are you aware of instances where Pat Cipollone threatened to resign?
I kind of, like I said, my interest at that time was on trying to get as many pardons done. And I know that, he was always, him and the team were always saying, oh, we're going to resign. We're not going to be here if this happens, if that happens. So I kind of took it up to just be whining, to be honest with you.
Whining. There's a reason why people serving in our government take an oath to the Constitution. As our founding fathers recognized, democracy is fragile. People in positions of public trust are duty-bound to defend it, to step forward when action is required. In our country, we don't swear an oath to an individual or a political party. We take our oath to defend the United States Constitution. And that oath must mean something. Tonight, I say this to my Republican colleagues who are defending the indefensible. There will come a day when Donald Trump is gone, but your dishonor will remain.
I also believed that our investigation needed to be clear about its principal purpose, to preserve the foundations of our republic. So I ended this way.
Finally, I ask all of our fellow Americans, as you watch our hearings over the coming weeks, please remember what's at stake. Remember the men and women who have fought and died so that we can live under the rule of law, not the rule of men. I ask you to think of the scene in our Capitol Rotunda on the night of January 6th. There, in a sacred space in our constitutional republic, the place where our presidents lie in state, watched over by statues of Washington and Jefferson, Lincoln and Grant, Eisenhower, Ford, and Reagan. Against every wall that night encircling the room, there were SWAT teams, men and women in tactical gear with long guns, deployed inside our Capitol building. There in the rotunda, these brave men and women rested beneath paintings depicting the earliest scenes of our republic, including one painted in 1824 depicting George Washington resigning his commission, voluntarily relinquishing power, handing control of the Continental Army back to Congress. With this noble act, Washington set the indispensable example of the peaceful transfer of power, what President Reagan called nothing less than a miracle. The sacred obligation to defend this peaceful transfer of power has been honored by every American president, except one. As Americans, we all have a duty to ensure that what happened on January 6th never happens again, to set aside partisan battles, to stand together to perpetuate and preserve our great republic. Thank you, Mr. Chairman.
When I finished my opening statement, Chairman Thompson introduced a video presentation of the terrible violence of January 6th. He cautioned viewers that much of what they were about to see would be very difficult to watch, and it was. It was graphic footage of the attack, some from police body cameras, and much that had never been seen before. It reminded viewers of the devastating attack that day and our responsibility to ensure it never happens again. The committee then recessed for 10 minutes, and members gathered in the holding room behind the dais. After 11 months of intense preparation, the hearings of the United States House Select Committee to investigate the January 6th attack on the United States Capitol were finally underway. In the span of just an hour, we had shared more evidence than the public had ever seen. Apart from the committee members and a handful of staffers, few people had previously seen the full picture of where we were headed or how we intended to get there. But now they knew, and they knew in detail. Nearly 20 million Americans watched our June 9th hearing live, and it would eventually be streamed by millions more, an audience far bigger than we had anticipated. A major purpose of these hearings was to inform the public of the evidence and the truth, and we were reaching people. After a few more minutes, we returned to the hearing room and resumed our work. Chairman Thompson gavelled the committee back into session to hear the testimony of Capitol Police Officer Caroline Edwards. 44. I was slipping in people's blood. Officer Caroline Edwards, assigned to a special unit of the Capitol Police, trained to respond to mass demonstrations, was stationed on the west side of the Capitol on January 6th, when the mob broke through the perimeter of metal bike racks. She was struck by a Trump rioter and knocked unconscious. After coming to, Officer Edwards did not ask to be evacuated. Instead, she resumed duty immediately on the Capitol steps and attempted to hold the line on the lower west terrace. She was sprayed in the eyes with a noxious chemical irritant, possibly pepper spray or something else. She was tear gassed, and yet she continued. Listen to her describe the scene.
When I fell behind that line and I can just remember my breath catching in my throat because what I saw was just a war scene. It was something like I'd seen out of the movies. I couldn't believe my eyes. There were officers on the ground, they were bleeding, they were throwing up, they had, I saw friends with blood all over their faces. I was slipping in people's blood. I was catching people as they fell. It was carnage. It was chaos. I can't even describe what I saw. Never in my wildest dreams did I think that as a police officer, as a law enforcement officer, I would find myself in the middle of a battle. I'm trained to detain, a couple of subjects and handle a crowd, but I'm not combat trained. And that day, it was just hours of hand-to-hand combat, hours of dealing with things that were way beyond any law enforcement officer has ever trained for. And I just remember that moment of stepping behind the line and just seeing the absolute war zone that the West Front had become.
The testimony of Officer Caroline Edwards stirred the same anger and resolve that had motivated me since I sat in the House chamber on January 6th. These members of our Capitol Police had sacrificed for each of us and for the same Constitution we all swore to uphold. My grandmother had been the first female deputy sheriff in Natrona County, Wyoming, and I thought of her. It did not matter to me how these hearings might affect my election prospects or my campaign or my future in politics. This was more important. My father once described being profoundly moved when he heard President John F. Kennedy speak at the University of Wyoming in September 1963. He recounted hearing President Kennedy urge the students to recognize the importance of service to our nation. In that speech, Kennedy talked about the ancient Greeks and their definition of happiness: full use of your powers along lines of excellence. In no area of life, the president told the students, would it be more important to use whatever powers you have and to use them along more excellent lines than in service to our country. Later, I would learn that Democratic Majority Leader Steny Hoyer had been motivated to run for office by a similar Kennedy speech at the University of Maryland. No matter your party, government service should be noble, based on love of country and commitment to principles. But what I saw from my party now was unprincipled. All those who hold office must make a choice of how they will serve and what they will try to achieve for their country. Members of Congress have a critical responsibility. They must do their duty to our Constitution and our country. Officer Caroline Edwards' testimony was a reminder of what was at stake. We knew we had a huge job ahead of us. One commentator at the time wrote, "Throughout June, the committee has to weave together thousands of hours of testimony, tens of thousands of documents, and make it all coherent, compelling, and as concise as Congress can be." In its first primetime hearings, the committee did that expertly. A few days later, Donald Trump Jr. was appearing at a campaign rally for one of my opponents, a few miles from our home in Jackson, Wyoming. A Trump supporter had posted my home address online and encouraged people to converge on our house after the rally. I had to call one of our daughters, who was home alone that day, and tell her to leave the house immediately. Violence, and more specifically, the threat of violence against Trump's political opponents, was a reality that threatened our families too. 45. A grave disservice to the country. In the weeks before the hearings, I asked our investigative team to help compile a catalog of how the January 6th rioters had described their motivations. Exactly why did they believe they'd been called upon to, quote, take back our country? Why had they come to Washington? And why had hundreds of them violated the law and sacrificed their freedom? This inventory built upon work my daughter Elizabeth had done as a research assistant over the months beforehand, compiling statements by defendants in all the ongoing prosecutions. Nearly every defendant and almost every person who can be found on video explaining their actions on January 6th makes it clear that they were in Washington at Donald Trump's behest to stop the steal, to halt what Trump had told them was a corrupt conspiracy by Democrats and rhinos, Republicans in name only, to rob him of the presidency. Almost none of the rioters had any inkling of the massive amount of information that Donald Trump had received in private, rebutting each of his stolen election claims. They were, nearly all of them, deceived. With some exceptions, our preparations for hearings followed a common pattern. The starting point was the initial outline Phil and I had prepared, and my opening statement from our June 9th hearing. We would work to compose a hearing outline with many specific additional details and further evidence we wanted to address. I would discuss the outlines with Joe Maher, Jamie Fleet, Terry McCullough, James Goldston, and Tim Mulvey. The committee lawyers who had interviewed the subject witnesses and knew the evidence best would work very closely with us to identify and verify the material to be presented. They would draft witness questions and ensure that the presentation was accurate and true to the evidence the committee had gathered. Our committee teams would also expertly develop video presentations on certain topics, such as the fake elector scheme, to help present a significant volume of evidence in a summary fashion. The committee members responsible for each hearing would edit their own sections. They were responsible for shaping their opening remarks and deciding what they would ask. We would then go through multiple rounds of edits. This time-consuming process often involved restructuring portions of the planned hearings to ensure we were presenting the most important evidence fairly and effectively. It was important, so we committed a considerable amount of time to working on these drafts. James Goldston and Tim Mulvey oversaw a team of professionals, including some with many years of experience in television news. They worked with committee staff and attorneys to produce video compilations and other visual exhibits to help us effectively convey the evidence we were uncovering. The committee would then conduct at least one and often several run-throughs, where staff and members would all discuss further edits. Often the committee lawyers would stand in for witnesses during these practice sessions. Almost all the practice sessions occurred from the dais in the same hearing room where we conducted the actual hearings. At all times, the emphasis was on accuracy. We worked to avoid partisanship and exaggeration. Our second 2022 hearing on June 13th focused in great detail on exactly what Donald Trump knew at the time he was telling Americans that his supposed landslide victory had been stolen from him. Zoe Lofgren led this hearing. I had not known Zoe well before our work together on the committee, but I was aware of her reputation as one of the most effective and respected members of the House of Representatives. She is thoughtful and serious, and she operates with zero ego, a rarity in Congress. Throughout our work on the committee, Zoe was a source of wisdom and good judgment on a range of issues, from legal analysis to helping me understand and navigate the dynamics and relationships inside the House Democratic Caucus. Our June 13th hearing included extensive testimony from members of Donald Trump's 2020 presidential campaign. In some cases, it seemed as if they had been waiting for months to unburden themselves of what they knew and what they had seen. Zoe presented evidence that Trump's own campaign advisors had told him not long after the election that he had likely lost. And then they confirmed that he had indeed lost in the week or so that followed. Efforts to find fraud, overseen by lawyers for the Trump campaign, had uncovered no fraud sufficient to overturn the election in any state. Trump campaign lawyer Alex Cannon told the committee he had conveyed this to Mark Meadows in mid to late November 2020. In response, Meadows had said, "So there's no there there." Men and women who had loyally served President Trump knew it was over. And later, even as I was writing this book, yet more details emerged. Two expert analyses, both apparently commissioned by the Trump campaign, reportedly reached this same conclusion. In the nearly 3 years since January 6, 2021, no genuine evidence has come out that could substantiate Trump's stolen election claims. It was all a lie. On the morning of our June 13th hearing, we learned that one of our principal witnesses, Donald Trump's campaign manager Bill Stepien, would be unable to testify. Although Stepien had been in Washington and was prepared to testify, he informed the committee that his wife had gone into labor. We had already selected video clips from Stepien's prior interview on each point that our questioning planned to address. The staff quickly pivoted from live testimony to recorded video, and the committee conducted the hearing. Stepien believed that Trump's allegations of fraud were not, quote, honest or professional. His conviction that Trump's election claims were false placed him squarely amid a large group of Trump campaign officials and Trump administration appointees who had concluded the same thing. Even though Bill Stepien was unavailable, other witnesses testified live that day. A longtime, well-respected Republican election lawyer, Ben Ginsberg, explained what the scores of lawsuits had concluded, that Trump was wrong. 22 federal judges appointed by Republican presidents, including 10 appointed by President Trump himself, and at least 24 elected or appointed Republican state judges, dismissed Trump's claims. As Ginsburg pointed out, dozens of courts had analyzed the underlying factual allegations and ruled against Trump and his allies.
In all the cases that were brought, and I've looked at the more than 60 that include more than 180 counts. The simple fact is that the Trump campaign did not make its case. And in no instance did a court find that the charges of fraud were real.
Former Fox News political editor Chris Stirewalt, one of the leaders of the Fox News decision desk responsible for the network's accurate call of Arizona for Joe Biden on election night, explained that the red mirage happens in every presidential election cycle. Republicans tend to vote in person in greater numbers on Election Day, whereas Democrats increasingly vote early or absentee. So it's not unusual for states that count their Election Day votes first to show an early Republican lead that diminishes as mail-in votes are counted. Happens every time, Stirewalt said. But until Donald Trump, who falsely claimed that the red mirage proved the election had been rigged, no presidential candidate had ever lied about it. In this hearing, we also presented evidence from a long list of witnesses who had spoken directly with Trump. Here's Acting Deputy Attorney General Richard Donahue.
I tried to, again, put this in perspective and to try to put it in very clear terms to the president. And I said something to the effect of, sir, we've done dozens of investigations, hundreds of interviews. The major allegations are not supported by the evidence developed. We've looked in Georgia, Pennsylvania, Michigan, Nevada. We're doing our job. Much of the info you're getting is false.
And here's Attorney General Bill Barr.
In that context, I made it clear I did not agree with the idea of saying the election was stolen and putting out this stuff, which I told the president was bullshit. And, I didn't want to be a part of it.
Here's what Attorney General Barr said about Dominion voting systems.
And I told him that the stuff that his people were shoveling out to the public was bullshit. I mean, that the claims of fraud were bullshit. And, he was indignant about that. And I reiterated that they'd wasted a whole month on these claims on the Dominion voting machines, and they were idiotic claims. And I told them that it was crazy stuff, and they were wasting their time on that. And it was doing a grave disservice to the country.
Here's Acting Attorney General Jeff Rosen.
We know that you're getting bad information. That's not correct. It's been demonstrated to be incorrect.
And here's what Trump campaign General Counsel Matt Morgan told us.
I think I had conversations with probably all of our counsel who are signed up to assist on Election Day as they disengaged with the campaign. The general consensus was that the law firms were not comfortable making the arguments that Rudy Giuliani was making publicly. I seem to recall that I had a similar conversation with most all of them.
With all that testimony and much more, we reached the unavoidable conclusion. No person of even reasonable intellect who heard this information could believe that Donald Trump had won the election. Before our hearings, only a small part of this detail was available to the general public. Donald Trump's ads, speeches, and social media posts had relentlessly repeated the same false allegations that these witnesses debunked. When we ultimately compiled all this information for our final report, I asked staffers on the January 6th committee to create a detailed chart. It would inform the public exactly when Donald Trump had been told that certain fraud allegations were false, and exactly when Donald Trump had said the opposite in a public forum. That chart, perhaps the most easily understood summary of Trump's fraud, can now be found in the report on pages 22 to 27. And Special Counsel Jack Smith's August 2023 indictment of Donald Trump has since identified even more evidence of Trump's intentional deceit. Our hearings also disclosed communications from the days leading up to January 6th from Donald Trump's senior campaign advisor Jason Miller and other witnesses. The evidence indicated that even Rudy Giuliani's legal team knew, in the days before January 6th, that they had failed to prove that any alleged fraud had altered the election results in any state, much less in multiple states. But that did not stop Donald Trump and a number of his allies, including those in Congress, from proceeding with their plan to overturn the election on January 6th. It's important to compare the Trump team's knowledge at the time with what Donald Trump, Rudy Giuliani, and John Eastman said at the president's January 6th ellipse rally before tens of thousands of angry supporters whom Trump was directing to march to the Capitol. Their speeches continued to fraudulently claim that Dominion voting systems machines had corrupted the election. Rudy Giuliani urged, quote, trial by combat, while Donald Trump said this: when you catch somebody in a fraud, you're allowed to go by very different rules. Donald Trump has frequently returned to this notion that his election fraud allegations justified unconstitutional and illegal acts. He has said, for example, a massive fraud of this type and magnitude allows for the termination of all rules, regulations, and articles, even those found in the Constitution. The day after our June 13th hearing, columnist Max Boot, who admitted he had been skeptical that the committee's hearings would provide any new information, wrote an editorial suggesting we were accomplishing at least part of what we had been striving to do since the prior summer. Boot wrote this: the committee's hearings are exceeding expectations because it is not behaving like a typical congressional committee. There is no grandstanding and no preening. There are no petty partisan squabbles. There is not even the disjointedness that normally occurs when a bunch of politicians are each given 5 minutes to question each witness. There is only the relentless march of evidence, all of it deeply incriminating to a certain former president who keeps insisting that he was robbed of his rightful election victory. 46. Tantamount to a revolution. Like so much of the story of January 6th, the story of President Trump pressuring Mike Pence to violate the law and his oath to the Constitution tells us exactly who Donald Trump is. The committee's June 16, 2022 hearing, led by Democratic Congressman Pete Aguilar, covered all the elements of Trump's pressure campaign against his own vice president. Under our Constitution, the vice president is a member of both the executive branch and the legislative branch, where he or she serves as the president of the Senate. The president of the Senate's role on January 6th is set forth in clear terms in our Constitution's 12th Amendment. Quote, the president of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes for president shall be the president. This seems like a very straightforward instruction, and in almost all instances it is. On January 6th, Mike Pence's role was purely ministerial, purely procedural. He could not change the result of the election. Our Constitution unambiguously instructed him to open envelopes so the electoral votes could then be counted, period. Donald Trump did not have the power to instruct Mike Pence to do something different than that. Mike Pence could not refuse to open the envelopes. He could not prevent the counting. Mike Pence could not determine that a particular set of official state electoral votes was not to be counted. Mike Pence could not decline to do what the Constitution required because he didn't like how the recounts had gone in a certain state, or because he disagreed with how state and federal courts, including the U.S. Supreme Court, had resolved legal issues about an election in any state. He was simply required to open the envelopes so the votes could be counted. Pence, in his role as president of the Senate, reached the correct conclusion that he could do none of those things on January 6th. As he later said, there is no idea more un-American than the notion that any one person could choose the American president. Mike Pence's White House lawyer, Greg Jacob, knew Pence was right. Mike Pence's private lawyers, as well as those they consulted, knew he was right. Donald Trump's White House counsel, Pat Cipollone, and every other White House lawyer who knew what was happening knew that Pence was right. And evidence gathered by the January 6th Select Committee showed that even John Eastman, the lawyer advising Trump at the time, admitted in a meeting with Donald Trump himself that his and Trump's plan violated the law. Greg Jacob wrote this in a contemporaneous memo. Quote, Professor Eastman acknowledges that his proposal violates several provisions of statutory law. As Eastman wrote before the 2020 election, the 12th Amendment only says that the President of the Senate opens the ballots in the joint session, then, in the passive voice, that the votes shall then be counted. 3 U.S.C. Section 12 of the Electoral Count Act says merely that he is the presiding officer, and then it spells out specific procedures, presumptions, and default rules for which slates will be counted. Nowhere does it suggest that the President of the Senate gets to make the determination on his own. Section 15 of the Electoral Count Act doesn't either. But Donald Trump would not accept the truth. In fact, Donald Trump did not care about the truth. In an email exchange between Greg Jacob and John Eastman during the violence, Jacob asked Eastman, "Did you advise the president that in your professional judgment, the vice president does not have the power to decide things unilaterally?" Eastman responded that Trump had been, quote, so advised. Then Eastman continued, "But you know him. Once he gets something in his head, it is hard to get him to change course." Donald Trump would not accept Mike Pence's conclusion, as president of the Senate, that he could not legally do what Trump wanted him to do. So Trump reacted persistently with anger and with repeated threats to try to force Mike Pence into doing something that Pence and others had already told Trump was illegal. Trump yelled at Pence in front of witnesses who later testified about it. Trump used profanities, including the P word. Trump tweeted at Pence again and again, telling the world that Mike Pence could deliver the presidency to him on January 6th. On January 5th, Trump issued a statement he knew to be false. He claimed that he and Pence were in agreement that Pence could refuse to count electoral votes. The next day, Trump told an angry ellipse crowd in clear and unequivocal terms that Mike Pence could deliver the election for Donald Trump. He then directed that crowd to march to the Capitol. And when Donald Trump already knew that the crowd had reached the Capitol and turned violent, and that none of his efforts to cow Pence had worked, Donald Trump attacked his vice president once again, this time in a tweet accusing Pence of having failed to deliver the election. That triggered many in the crowd to surge forward into the Capitol as they hunted the vice president, chanting, "Hang Mike Pence." No man who would do these things can ever be our president again. Mike Pence did what was right. He deserves praise for standing up against a plan that was obviously illegal. The day after the violent assault, White House lawyer Eric Hirschman counseled Trump's lawyer John Eastman.
I said, "Good, John. Now I'm going to give you the best free legal advice you're ever getting in your life. Get a great effing criminal defense lawyer. You're going to need it." And then I hung up on him.
According to federal judge David Carter, Donald Trump's plan to pressure Mike Pence likely violated multiple federal criminal statutes. After Greg Jacobs' initial interview, we had no doubt that Donald Trump knew that what he was demanding Mike Pence do was illegal. Jacob also described working with Pence to prepare a public letter that would announce Pence's decision on January 6th, that the Constitution prevented him from doing what Trump wanted. According to Jacob, Pence said the letter was, quote, "the most important thing I ever say." It probably was. Of course, that letter is what led Donald Trump to put Pence's life at risk less than 2 hours later with his 2:24 p.m. tweet. The letter that Mike Pence issued at approximately 1 p.m. on January 6th said exactly the right thing about his role as president of the Senate. Pence lacked the authority to refuse to count electoral votes. But the letter also contained what seemed to be a political compromise. It suggested that Congress had the power, through its objections process under the Electoral Count Act, to determine who could be president. The framers of our Constitution did not give a majority in Congress the authority to veto the outcome of a presidential election by opting not to count electoral votes from whatever states they choose. If that were so, and if Republicans had held a majority of the House and Senate on January 6, 2021, they could have declared Trump the winner no matter the final tally of Electoral College votes. A future Democratic bicameral majority might similarly attempt to pick a Democrat for president, even if a Republican won. Mike Pence was reading the simple text, "The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted," correctly, on one hand, to say he personally had only a ministerial role. But then Pence read the same text incorrectly to say that Congress had some authority on January 6th to object and potentially reverse the election outcome by refusing to count electoral votes. On January 6th, there was no ambiguity about what that simple sentence required. We had only one certified electoral slate for each state. Each slate had to be counted. Indeed, it appeared to us that Pence's own counsel, Greg Jacob, may not have shared Pence's view about objections. At the very end of his recorded committee interview, Jacob said this: "In my view, a lot has been said about the fact that the role of the vice president in the electoral count on January 6th is purely ministerial, and that is a correct conclusion. But if you look at the constitutional text, the role of Congress is purely ministerial as well. You open the certificates and you count them. Those are the only things provided for in the Constitution." Americans must not lose sight of an appalling fact. Certain Republican members of the House of Representatives, including many members of the Freedom Caucus, fully supported what Donald Trump was trying to force Mike Pence to do. That is a crucial point. A significant number of House Republicans thought they could ignore the Electoral College result and find a way to reinstall Trump as president. As Judge J. Michael Ludig explained at our June 16th hearing,
"I believe that had Vice President Pence obeyed the orders from his president and the President of the United States of America during the joint session of the Congress of the United States on January 6, 2021, and declared Donald Trump the next President of the United States, that declaration of Donald Trump as the next president would have plunged America into what I believe would have been tantamount to a revolution within a constitutional crisis in America."
At the close of our June 16th hearing, Judge Ludig described the prevailing state of affairs this way: Donald Trump and his allies are a clear and present danger to American democracy. And as Judge Carter had concluded, President Trump's pressure campaign to stop the electoral count did not end with Vice President Mike Pence. It targeted every tier of federal and state elected officials. The next hearing of the January 6th committee would tackle precisely that issue. 47. Conspiracy theories and thug violence. We had a number of goals for our June 21st hearing. First, we wanted to show the astounding amount of effort Donald Trump had devoted to trying to change state electoral votes from Biden to Trump. Trump called legislators in every state at issue and election officials in virtually every state at issue. He tried to persuade them, he tried to pressure them, he threatened them. One of those conversations was caught on tape. In it, Donald Trump presses Georgia Secretary of State Brad Raffensperger to find 11,780 votes for Trump, informing Raffensperger that he may be criminally liable if he does not. A similar call, reportedly with then-Governor Doug Ducey of Arizona, came to light in 2023. Among other things, Trump wanted to change the election outcome by having state legislatures replace the Biden electors with Trump electors. This was illegal, as even John Eastman had acknowledged in writing before the 2020 election. In the end, despite the Trump pressure, not a single Republican governor or Secretary of State relented, and not one state legislature tried to alter the official and lawful electoral votes. You might think Trump's failure to persuade state legislatures to illegally upend the election would have ended his efforts to overturn the election. It did not. He continued with his plot regardless. We also knew it was imperative to reveal what else had transpired in each state during Trump's effort to apply pressure on individuals to abandon their oath. Individual state office holders, individual election workers, and legislators, along with their families, were subject to threats of violence, intimidation, and harassment. The threats began in November and December 2020, and they were publicized far in advance of January 6th. On December 1st, 2020, more than a month before the attack on the U.S. Capitol, Georgia elections official Gabriel Sterling pleaded with President Trump in an extraordinary and emotional speech at the Georgia State Capitol. He began with this: "It has all gone too far, all of it." And then Sterling elaborated with specifics.
A 20-something tech in Gwinnett County today has death threats and a noose put out saying he should be hung for treason because he was transferring a report on batches from an EMS to a county computer so he could read it. It has to stop. Mr. President, you have not condemned these actions or this language. Senators, you have not condemned this language or these actions. This has to stop. We need you to step up, and if you're going to take a position of leadership, show some. This is elections. This is the backbone of democracy, and all of you who have not said a damn word are complicit in this.
Sterling further urged the president to
stop inspiring people to commit potential acts of violence. Someone's going to get hurt, someone's going to get shot, someone's going to get killed. And it's not right.
This was all the warning Donald Trump or anyone else needed, that the Trump strategy could lead to violence. Clear as a bell, more than a month before January 6th. But nothing stopped, nothing changed. In addition to what Trump had said on the private call with Georgia Secretary of State Brad Raffensperger, Trump also attacked Raffensperger publicly. Raffensperger described the vile messages and harassment targeting his family.
And so I was getting text all over the country, and then eventually my wife started getting the text, and hers typically came in as sexualized texts, which were disgusting. You have to understand that Trish and I, we met in high school, and we've been married over 40 years now. And so they started going after her, I think, just to probably put pressure on me. Why don't you just quit, walk away? And so that happened. And then some people broke into my daughter-in-law's home, and my son has passed, and she's a widow and has 2 kids.
As our hearing evidence showed, similar situations were playing out in several other states where Donald Trump was pressuring local officials. Many of them faced threats or harassment prompted by Trump. We played testimony from Michigan, for example, where Secretary of State Jocelyn Benson described angry Trump protesters surrounding her home while she was inside with her son, and threatening clerks and election officials across the state. Election deniers also made violent threats against Stephen Risher. He is a longtime Republican who successfully ran for election as the recorder of Maricopa County, Arizona in 2020. After taking office, and after Trump and his supporters lodged false complaints about a rigged election in this key Arizona county, Risher investigated the facts himself in his new role. He had no motive to cover up any problems with the election. His election opponent was the incumbent in 2020 and had overseen the election. But after an exhaustive review, he concluded that Biden had fairly won the vote in Maricopa County. He published an open letter to Republicans to explain, in great detail, why the election results were valid. Ever since, he and his family have been subjected to abusive, violent threats from individuals across the country. But he continues to stand firm on the facts. Speaker of the Arizona State House of Representatives, Rusty Bowers, testified live. I had met Bowers once before, at the Kennedy Presidential Library, when we were both honored with the Profile and Courage Award. I had tremendous respect for his devotion to the principles of honor and justice, and his deeply held religious faith. Donald Trump and Rudy Giuliani had both called Speaker Bowers on multiple occasions, urging him to reverse or cast doubt on the election result in Arizona, where Biden had won by over 10,000 votes. Bowers asked Giuliani repeatedly for hard evidence that the election had been corrupted. Bowers testified that Giuliani eventually admitted, quote, "We've got lots of theories, we just don't have the evidence." Speaker Bowers' testimony made it clear he had no axe to grind. Here's his exchange with Representative Adam Schiff during our June 21st, 2022 hearing.
Did you tell the president in that second call that you supported him, that you voted for him, but that you were not going to do anything illegal for him?
I did, sir.
Speaker Bowers also described becoming a target of the same type of intimidation tactics that we had seen Trump supporters use elsewhere.
Various groups come by and they have had video panel trucks with videos of me proclaiming me to be a pedophile and a pervert and a corrupt and politician, and blaring loudspeakers in my neighborhood, and leaving literature both on my property.
Among the worst incidents of Donald Trump's political intimidation campaign was what he and Rudy Giuliani did to Georgia election workers Shaye Moss and her mother Ruby Freeman. Moss, too, had received a Profile and Courage Award, and I had met them both at the ceremony where Rusty Bowers was also honored. Trump and Rudy Giuliani had a theory, hatched from watching a video, that Moss and Freeman had somehow utilized a thumb drive to corrupt the machines tabulating votes in Fulton County, Georgia. The video in question showed Freeman handing Moss something small. It was not a thumb drive. It was a ginger mint. But Donald Trump attacked both Moss and Freeman relentlessly on a national stage, describing Ruby Freeman as, quote, "a professional vote scammer and hustler." Our hearing described how a group of Trump supporters had appeared at Freeman's house, barged through her front door, and tried to perform a citizen's arrest. In the wake of the incident, the FBI cautioned Freeman that it was no longer safe for her to remain in her own home. Freeman recounted the traumatic episode this way.
There is nowhere I feel safe. Nowhere. Do you know how it feels to have the President of the United States to target you? The President of the United States is supposed to represent every American, not to target one. But he targeted me, Lady Ruby, a small business owner, a mother, a proud American citizen who stand up to help Fulton County run an election in the middle of the pandemic.
In July 2023, eager to settle the defamation case against him brought by Freeman and Moss, Rudy Giuliani admitted in court documents that his statements about them were false. After their testimony, Chairman Benny Thompson and I walked over to the witness table and thanked Ruby Freeman and Shaye Moss for their courage. Nobody with any sense of honor or dignity would have treated them the way Donald Trump, Rudy Giuliani, and others working on Trump's behalf had done. Just as there is no excuse for provoking violence against our Capitol, there is no defense for targeting a state house or state official, a courthouse, a judge or justice, or any election worker. In addition to the pressure Trump and his allies exerted on state election officials, this hearing addressed another vital topic: Donald Trump's scheme to create fake electoral slates. Evidence indicated that the White House counsel's office was concerned about the plans for fake slates. By December 2020, in fact, multiple lawyers on the Trump campaign understood it was illegal and refused to participate in the effort. Despite this, the committee showed that Trump plowed ahead, personally asking RNC chairwoman Ronna McDaniel for assistance. McDaniel testified to the committee that she had directed her RNC staff to help the campaign assemble the fake electors. On December 14th, McDaniel was able to report to President Trump that the fake Trump electors had met and voted in states Biden had won. One of our witnesses testified that he absolutely would not have participated in the fake electors scheme. Quote, "If I had known that the three main lawyers for the campaign that I had spoken to in the past were not on board." The plan was that Vice President Pence could rely on the fake electoral slates on January 6th to rationalize not counting the genuine electoral votes. As the committee demonstrated, Dr. John Eastman told the Trump campaign representative that it did not matter that the electors had not been approved by a state authority. As Dr. Eastman said, quote, "The fact that we have multiple slates of electors demonstrates the uncertainty of either. That should be enough." One key point about the fake electors slates is this: even after no state had attempted to reverse its lawful election outcome, even after no court of law had ruled in a way that could overturn any election, Donald Trump and his team still sent the false slates to the executive branch and to Congress, intending that they be utilized in Congress's official proceeding to count electoral votes. The slates were knowingly false, and the action was intended to obstruct the legitimate count of certified state electoral votes. It was all part of a larger conspiracy to steal the election. Donald Trump and everyone involved knew that the slates were fraudulent. The fake electoral slates were one of many issues the committee considered as we later drafted our criminal referrals. We believed at the time that the Department of Justice would certainly pursue this. It was a straightforward, unambiguous example of criminal conduct. And in fact, Department of Justice Special Counsel Jack Smith's indictment of Donald Trump did take this up directly. This June 21st hearing was ably led by Democratic Congressman Adam Schiff. His scrupulous attention to the evidence, as well as his careful and respectful questioning of the witnesses, helped to ensure that the American people understood the full picture of Donald Trump's pressure campaign on state officials. My sense was that our hearings were having a broad impact. Tens of millions of Americans were watching live. We were reaching people, and we were revealing facts almost entirely through Republican witnesses, the people who knew Donald Trump the best, the people who had worked with him the most closely. Each of our hearings had been conducted without partisan squabbling or posturing. It was clear, though, that no amount of evidence would ever convince a certain segment of the Republican Party. Throughout the 18 months of our work, certain Republican House members and senators who knew better elected to play to that audience anyway. Senator Tom Cotton, for example, went on conservative commentator Hugh Hewitt's radio show at one point and disparaged the hearings as a partisan exercise, and therefore inconsistent with, quote, Anglo-American jurisprudence. Senator Cotton then admitted that he had not watched any of the hearings. I respected Tom, and we had worked together over the years on a number of foreign policy and national security issues. He knew the truth about what Trump had done and was continuing to do, and I didn't want to let him get away with such a cheap shot at the committee's work. I responded in a tweet. "Hey, Tom Cotton, heard you on Hugh Hewitt criticizing the January 6th hearings. Then you said the strangest thing. You admitted you hadn't watched any of them. Here's a tip. Actually watching them before rendering judgment is more consistent with Anglo-American jurisprudence. While I knew that most of my colleagues didn't actually believe Donald Trump's lies, millions of others did believe them. We needed to take advantage of the progress we were making in presenting the facts, largely through Republican witnesses, and push for even more critically important testimony. 48. It may have spiraled us into a constitutional crisis. By the time we began our hearings in June 2022, Donald Trump's dealings with Department of Justice official Jeffrey Clark had already gotten some press. The DOJ's Inspector General had reportedly been investigating, and a Senate committee had interviewed some of the people involved. My opening statement at our first hearing had highlighted how we thought Trump's dealings with Clark fit into Trump's larger plans to overturn the election.